All right, welcome everybody. All right, thank you. Welcome everybody to the Ad Hoc Commission on the Discipline System. It is our 12:30 to 4:30 meeting, and I would like Justin, if you could take roll call, please. Looks like someone has maybe multiple microphones turned on. So if you've called in, plus you're on the computer, you need to mute one. All right, hopefully that fixes it.
The host would like to join in with your microphone. You can press star to join.
Okay, can you hear me?
Yes.
Okay. Karen Bell.
Oh, here.
So it'll be its own status.
Michelle Anderson. Ray Buenaventura.
Present.
Janae Buffington. Hyland Chen. Ruben Duran. Sharon Ershardi.
Here.
Gary Farwell. Sarah Good.
I'm here, but not at the back like Keith. Location.
Jenna Jones. Shalon Joseph. Janet King. Jerry Larkin.
Here.
Melanie Lawrence. Ed Lear.
Here.
Alexia Mayorga.
Here.
Judge McGill.
Here.
Steve Moat. Cynthia McCown. Ellen Pansky.
Here.
Eloise Rosenblatt.
Here.
Linda Schneider.
Yes, I'm here.
Sean Selig.
Here.
Brandon Stallings. I know you're here, Brandon.
Oh, here.
Judge Wang
Good afternoon, present.
and Martin Winfield. I don't see. We have 13.
So Justin, this is unusual, but I sent Ellen my link. So it looks like I have 2 boxes and Ellen might be in my second box.
Okay.
Just clarifying.
Okay.
There she is.
Just a minute if you mute your computer. Yeah, I'm trying to.
So you didn't hear me say here, I guess?
I did.
Okay, all right, thank you.
Okay. So once
We're getting some feedback still.
I apologize. One moment.
All right, so I think we're having issues with the audio. Can everybody hear me? All right, great. So we are one short of quorum. However, we've been advised by general counsel that we can take public comment and that we can also discuss items as long as no action is taken on the items. Is there any objection from any member of this body or any questions for Office of General Counsel?
No, but one thing, if we do happen to get a quorum, I've got to leave at 3:30. So if we get a quorum, I guess we should try to really get all the action items done as quickly as possible.
Hey, I am all for getting action items done as quickly as possible. So that sounds like a great idea. And before we get into that discussion, though, I want to make a call for public comment. Is there any member of the public who wishes to address this commission? Justin, do you see anybody in our attendees list with a raised hand?
Yes, can you hear me? Yes, you can hear me? Okay. It looks like Dido Clark would like to make a comment. I have unmuted.
All right, thank you. You have 3 minutes. Thank you for addressing our body.
Thank you. Am I on now?
Yes.
I am Dido Clark, State Bar number 79876. And I wanted to address defects in the expungement recommendations. Problems with your expungement recommendations include the following. 1, your expungement recommendations inappropriately presume that state bar prosecutors and the state bar court are infallible and that all disciplined attorneys are guilty as charged. And 2, your expungement recommendations are inconsistent with the state bar prosecutor's duties to take reasonable remedial measures and to seek to remedy wrongful convictions. To cure these problems, I propose that you all add 2 provisions. 1, the time requirements between conviction and expungement should not apply in cases where clear and convincing evidence supports the proposition that an attorney was wrongly or erroneously convicted, because justice delayed is justice denied. And 2, when clear and convincing evidence supports the proposition that an attorney was wrongly or erroneously convicted, the prosecutor should help expunge that attorney's record. And the citations for my recommendations are Rules of Professional Conduct 3.3A3 and 3.3G, duties to take reasonable remedial measures and to seek to remedy the wrongful convictions, and B, Business and Professions Code section 6092.5E, expunge records as directed by the California Supreme Court. And the way this would work would be the opposite of what the way the statute reads. It would
You have
be
30 seconds.
Thank you. It would be a request from the state bar prosecutor to the state bar court to the California Supreme Court. Thank you very much.
All right, thank you for your public comment. Any other members of the public?
Does not appear.
All right, going once, going twice.
Wait, Justin?
Yes.
Sorry, who's one? I'm just curious. Who's 1415?
That's the Polycom phone that we're having in the room.
Okay, thanks.
All right, going once, going twice. All right, thank you for your public comment, everyone. All right, so as far as our goals today, what we really would like to do, and in keeping with Judge McGill's comments about getting to votes quickly as soon as we have a quorum. What I'd like to do is try and get to the items that the members of the various working groups have worked on. If they are on and we have a quorum at that point, then I'd like to try and take action on those items. But really what we're going to do is take action on items that we can today. Out of those action items, we will create a report. And then after that report is created, then that will be distributed. That report will be distributed to the members of this committee with a request for any edits. And then also, if any members of the commission wish to basically give a dissenting opinion or dissenting vote as to, and the reasons why behind the why you oppose the ultimate recommendation of the commission, then that would give you that time. And then we will have a final meeting to approve the recommendations, and we anticipate that should hopefully not take all that long. So that is the game plan for today. Justin, have we obtained a quorum since we started?
I don't think so. I don't see anybody new.
Okay.
Yeah.
All right. Justin, with the individuals that we have on screen right now, are there any items that you think we should take up first as far as report, and then any other comments?
No, I think we can go in the order that we kind of discussed yesterday. We can start off with the NEC and then go into discipline costs and continue on from there.
Okay. All right, Justin, go ahead and take us through item 1 of our business agenda.
Okay, let me share my screen. And I will be a little disadvantaged today, so feel free, if I don't recognize the hand raised, feel free to speak up, or if someone else, Lisa, if you see someone, please feel free to call on them. Can everybody see the PowerPoint slide? All right. So thank you for coming to the Ad Hoc Commission on the Discipline System. It's been a long year plus that we've been going at this, and we're going to finally vote on some recommendations today. These are the recommendations that we're going to look at. There was a notice moral turpitude recommendation that can still be incorporated into the final report, but we haven't finalized that recommendation yet. And as Brandon said, the plan from here is to adopt some recommendations today so that we can get the final report drafted. The final report will be drafted by staff, and then it will be circulated to all members of the commission for additions, subtractions, edits. And then also there will be an opportunity if members of the commission have a dissenting opinion that they would like included in the report. So if a recommendation was that they didn't agree with, we will be accepting dissenting opinions too to be incorporated into the final report. Once we get that draft report fully vetted, we will schedule one final meeting of the full ad hoc commission to adopt that final report before it goes on to the Board of Trustees. So the first recommendation we're going to discuss today is the Early Neutral Evaluation Conference recommendations. As a reminder, we've had 4 full commission meetings prior to this one. So this will be our 5th full commission meeting. We had 8 subcommittee meetings, the Fairness Subcommittee and the Effectiveness Subcommittees, and we've had 18 working group meetings. So this commission has met quite frequently, and I really appreciate everybody's effort in attending those meetings and getting to where we are today. We published memos on these recommendations last week, and I'm hoping that everybody had a chance to read those memos. We have discussed each of these recommendations at previous working group meetings and at full commission meetings. And so my intent today is to kind of very quickly go over the recommendations, knowing that we've talked about them previously, and then just get into the arguments for the recommendations and the arguments against the recommendations, and then have a discussion and ultimately take a vote on the recommendations. But If at any time any commission member has any questions or would like some background on it, feel free to raise your hand and ask for clarification or ask us to go in depth on a particular issue. I made the PowerPoint that will just kind of briefly go over the issue so we can get to that discussion of the proponents and the opponents. These are the two recommendations that came out of the early neutral evaluation conference. One has to do with criminal conviction cases, and one has to do with subsequent E&EC timelines. As a brief overview, the purpose of the E&EC is to obtain a judicial evaluation of OCTC's case. This is done, the timeline for the original E&EC is within 10 days of notice, the respondent has to request it, and then the hearing is supposed to, or the conference is supposed to be held within 15 days from that. The judge provides his opinion to the parties, an oral evaluation of the facts and charges. Criminal conviction matters. The clerks of the court in which an attorney is convicted shall have 48 hours after the conviction to transmit it to the Office of Chief Trial Counsel. Why we're talking about this today is the proposal is to allow for time for an E&EC in these criminal conviction matters. And these criminal conviction matters have to be transmitted to State Bar Court within 30 days. That 30-day deadline is in statute. A couple of years ago, that deadline was changed from 5 days to 30 days by the legislature to allow for a little more time for investigation. But this is the key component of the discussion on E&ECs in criminal conviction cases, because the recommendation is asking for time to have an E&EC conference in criminal conviction cases, which is not the case right now. The current timeline does not allow for an E&EC in criminal conviction cases. So the recommendations to seek that statutory change in deadline for criminal conviction matters to allow E&EC, there were arguments in support of this and there were arguments against it. And so we have summarized on the screen here, and it was in the memo, the arguments for support. And I will open it up shortly to the proponents of this measure so they can give a little more in-depth analysis on this. But it allows for cases to be resolved privately. It provides respondent an early assessment of the case, and analysis found, so Lisa's group in the Office of Research Institutional Accountability found that from March 2019 to February 2022, nearly half of misdemeanor criminal conviction cases were dismissed pre-trial. And this has to go with what was mentioned in the memo. It has to do a lot with quarry cases, which are cases that are much older than the normal criminal conviction cases. And recently the bar took on a fingerprinting project, and so we re-fingerprinted all the attorneys in the state of California because we were not receiving subsequent notifications of arrest records. And so when we went through that project, it discovered a lot of old convictions that were never originally reported to the bar. And so that's why a lot of these were dismissed, because they were a lot older convictions, and there could be many reasons. They were not relevant, or we couldn't obtain the documentation because they were 30 years old and we couldn't get the arrest reports. There are many reasons why they were dismissed, but this was a reason in support. The reasons against, I won't read them all, you can see them on the screen, but they had kind of centered around that the criminal convictions are already public, and that the recent legislative change to 30 days was all that they were willing to do, and so it was unlikely that they would grant a further time. So with that, I'm going to take down the slide, and hopefully we can begin the discussion with the proponents of allowing for a statutory change to allow for E&ECs in C cases. Someone like to speak on behalf?
All right.
May I speak?
Yes, go ahead.
I'm a proponent. Thank you for that, Justin. And wanted to clarify a couple of things. One of the things that supports this position insofar as ENECs are concerned with respect to criminal convictions is that it creates more judicial economy. And that is to say that the process, anytime there's a settlement process, in the experience of virtually any lawyer and judge, we would agree that there are cases that are resolved through that process and through the competence and talent of judges that creates a resolution that otherwise is not created without the ENEC process. And so in that regard, there's a judicial economy component to the proposal in favor. There's also another characteristic, which is the cost, that is to say less cost to not just the respondent, but I think also on the system, because to the extent that there is not an ENEC resulting in a resolution, then that case goes into the litigation system with the court and then creates an additional burden that would otherwise not be created if the matter were resolved through an ENEC. So I think for those reasons that there are some favorable aspects to this. I would argue that one of the issues or bullet points that is indicated as against the proposal is that it creates an additional strain on the system. I disagree with that for the aforementioned reasons, to wit, that there is judicial economy by virtue of resolving matters at the ENEC process with the expertise of judges who are facilitating settlements. Also, in one of the bullet points against was this idea that criminal convictions are already public. They may be, but they also may not be through the criminal justice expungement process. Oftentimes we rant on the defense side about how a criminal conviction that is otherwise expunged from the record through the criminal justice system would nevertheless be on a lawyer's public record for life through the way that the discipline system is set up. But for all those reasons, I would say that there is a benefit to the system, both from a cost point of view and from a judicial burden point of view. There's a benefit to the respondents from a personal cost point of view, and I simply think that it's the right thing. Thank you.
All right, Ms. Rosenblatt.
And could I just ask for clarification? I'm a family lawyer, so I don't know all the ins and outs of the criminal convictions. Could you just clarify what kinds of cases are resolved through ENECs? And clarify for me, what if there are 80% of non-CORI cases or CORI cases, what are those? So two questions. Just what kinds of cases do you find get resolved? What kind of criminal cases do you find get resolved through this process of judicial review and a pre-review? And what are the 80% of non-CORI cases referred to? I mean, what kind of cases are they?
So this is where I don't have our OCTC representatives here. The 80% of non-CORI cases are usually original matters. So those are matters that arise from complaints from the public. If you or I made a complaint against an attorney, they would open an investigation, and that would be an original matter. And those are a majority of the types of cases, whether that make up those non-CORI cases. And then the second question you had, I'm sorry, I can't remember.
The second question was, what kinds of cases are resolved? What kind of criminal cases get resolved through ENECs?
Well, currently, the criminal conviction cases aren't eligible for ENECs, so they're just trying to create that avenue where those criminal conviction cases, and those criminal conviction cases that we're talking about in the ENEC are misdemeanors, and they're misdemeanors that may involve moral turpitude. So I don't know if anybody can.
I mean, are we dealing with DUI cases, domestic violence assault cases, as opposed to domestic violence? I mean, there are lots of causes for a domestic violence conviction well, a conviction or a restraining order in criminal court as opposed to in a family court as opposed to criminal court. So I don't know.
Yeah, I think George is going to help me out here.
I would just say that as worded, the proposal doesn't limit the types of cases that would go to an ENEC. So in theory, any type of criminal case could go there. You know, whether they would resolve would be a matter for whatever discussions occurred between the court, OCTC, and the opposing counsel. So, you know, it's conceivable that a very serious case could be resolved, for example, if the respondent agreed to disbarment. On the other hand, it's likely that a number of more minor cases like misdemeanors might resolve if there was discussion and the court indicated that for whatever reason they didn't believe it was likely to result in significant discipline, and there might be a settlement of that type of case. So I think it's hard to predict what types of cases would actually settle at ENECs, but as of right now, at least the proposal doesn't limit, unless I'm misunderstanding, it doesn't limit the types of cases that would be.
Well, my concern would be that, you know, there are counties differ in how they interpret the domestic violence restraining order provisions, you know, in family court. And California is notable for its support of, you know, protection of women. But as we've seen in sports cases, you know, these obviously get resolved. So I wonder what the position of the state bar is on these cases. Are we going to support, you know, the, you know, I mean, we've had this Brock Turner dispute and the removal of Judge Aaron Persky on the bench over, you know, an interpretation of criminal law and criminal conviction. So I'm wondering, you know, is that a discussion that is relevant here to interpreting what kinds of cases and what kind of deal making over what kinds of cases would be done by the state bar? Or just a question.
Jerry has his hand up.
I would just add that in my observations in other states, discretion like this is built into the system. Now, George, it could be that there be some limitations on kind of cases that could be subject to this, but it almost has, it just allows systems to work more practically and express judgment better. There always are chances people will, you know, a group of people, the judge and the two parties will make a bad decision, but that's, we all have that as a risk every time we give any discretion. And I'm in favor of the discretion the proposal recommends.
And I have, you know, given the arguments of Judge Wang, and I'm very sympathetic to allowing the judge to, you know, exercise discretion rather than just be bound, you know, by rigid statutes. So I support discretion. I just am assuming and hoping that the protections that are provided for women in, you know, the domestic violence legislation, both in family court, when not so well in criminal court. I mean, there can be conflicts between those two courts, but I'm just hoping that one principle is that if an attorney is engaged in assaulting a spouse or other, that's not going to be dealt away by a, you know, somebody who thinks this is just a minor issue. I think it's a major issue. So that's my that's a comment. We don't have to have a, you know, and it's not it doesn't need an answer.
George, do you want to weigh in on either of those issues? Or Ms. Pansky, do you have something to add as far as questions, or are you okay waiting for George?
I'll wait for George.
All right, thank you.
Yeah, so I was just going to note that you know, whatever we do is going to require additional time. And so I think it is important to realize that if you are going to recommend an ENEC, you know, there's going to be the need for additional time. And I will just say that remember that our transmittal, when we get a certified record of conviction, our transmittal is required, you know, right now within 30 days. That is not time to hold an ESC. there would need to be an extension of that time frame. And I also would ask people to remember that, during that time frame, everything would remain confidential. And so in theory, even on a very serious crime, if a attorney requested an ENEC, it would delay the time in which the transmittal of that would render that public.
Hey, Brandon, just a point of order. I think we have a quorum now. So if we could pause real quick and call the roll again to establish a quorum.
Perfect. Let's do it.
I believe I have to recall everyone. So Michelle Anderson, Karen Bell.
Here, and I do have to step away from 2 to 2:30, just FYI.
Okay. Ray Buenaventura.
Present.
Shanae Buffington, Eileen Chen, Ruben Duran.
Present.
Shirin Urshardi.
Present.
Gary Farwell. Sarah Good. Jenna Jones. Shalon Joseph.
Present. Sorry for being late.
Thanks for attending. Janet King. Gary Larkin.
Present.
Melanie Lawrence. Edward Lear.
Here.
Alexia Mayorga.
Here.
Judge McGill.
Present.
Steve Moad. Cynthia Nakau. Ellen Pansky.
Present. I have a hard stop at 3.
Okay. Eloise Rosenblatt.
Present.
Linda Schneider.
Yes, I'm here.
Sean Seleg.
Here.
Brandon Stallings.
Here.
Judge Wang.
Present, but I'd like to take a break at 3 o'clock for 15 minutes.
Martin Winfield. Right. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. We have a quorum, 15 members.
Perfect. I know everybody's schedule is really evolving and definitely jam-packed. So appreciate everybody making time. So Justin, I want to just take a pause right now while we have a quorum. Do you feel like there are any items that are non-controversial or less controversial than this item that we could take up for a vote?
I'm not.
I
think we can
costs
continue
are
with
pretty
this one.
non-controversial.
What was that?
The discipline cost, I think, is fairly non-controversial in the recommendation. Maybe we should do that one.
Yeah, I would agree.
So can we take a pause then on ANEC and then switch over to discipline costs for a quick presentation and then any questions and a vote up or down?
Sure. And so everyone knows, even if we lose a member here or there, if you have a majority of the, I know we want to value everybody's vote, so I'm not cheapening into everybody's vote, and we should try and do everything while everybody's on the call, but we can still vote recommendations if people leave and we drop below quorum, as long as a majority of the members when the quorum was present still pass it. So just a point of order, but I can present really quickly on the discipline costs and sanctions if that's what the chair would prefer.
As long as we're on the ANEC, we're in the thick of that, and I think we're going to lose a couple people closer to 2. So let's continue with that then.
Okay.
All right. So I think where we left off, I think Ms. Pansky.
Yeah.
Thanks. Thank you. I am a bit concerned that this issue is not ripe for a vote today. I think that there's some confusion still about the ENEC process. And just briefly to try to clarify a few points for Eloise. An ENEC is an opportunity for the parties to bring the case and the defense before the judge. And even though technically speaking, It is for the purpose of allowing the parties to hear an independent judge's evaluation of the case. As a practical matter, it does serve as an early settlement conference, and a significant number of matters do settle at that level. If they don't settle at that level, and they go on to the pretrial process, there will typically be a voluntary settlement conference. So if the concern is about negotiating a disposition, that opportunity is going to come at some point before trial anyway. So that said, the types of cases that we're talking about in these misdemeanor convictions run the gamut. They involve things like trespass, sometimes DV, but most of them are in fact DUIs. And while it's true that there was a bubble that was created through the system when everybody got re-fingerprinted, DUIs are always a fairly well-represented proportion of misdemeanor conviction referrals. So it's the problem with this is that, as we've talked about several times, there is no current procedure to permit a respondent with what we might call a lower level misdemeanor or an aberrational criminal conviction out of many years of practice with no indication of any other problems, to have the opportunity to try to resolve that case, maybe for discipline, but potentially for something that won't be a public record, because there is something called a private reproval, which is discipline, but it's reserved for the lowest level of disciplinary matters. So the idea is that if somebody has a DUI or some other lower level misdemeanor, which occurred many years ago, in a lot of cases, we're talking 7, 10, 15. I have a case now where the issue is a misdemeanor that occurred 21 years ago. So the concern here is to permit those lawyers an opportunity to come forward before the matter becomes public and demonstrate that they've been fully rehabilitated and that they no longer present any kind of threat to either the clients, the public, or to the integrity of the legal profession. We don't have that now. I also want to say that there is not agreement among us on whether or not instituting a process to permit an ENEC to occur in a conviction proceeding before the matter goes public will necessarily require a statutory change. I don't want to speak for Judge Wang, but at one of our meetings, Judge Wang pointed out that if you read the statute carefully, it does not require that the matter become public. It requires that the matter be transmitted. So there is the ability for the rules of procedure to be changed to give the review department the discretion to refer a matter for what I would call not an ENEC, but a probable cause hearing. So that what the mandatory requirement is to refer for hearing a matter that either involves moral turpitude or which has been determined to be what we call a may or may not offense, meaning the facts and circumstances underlying this misdemeanor and a felony too. There are very few, but some do also fall into this category. Whether those facts and circumstances do or do not involve moral turpitude. There are a category of misdemeanors. It doesn't typically occur in a felony, but there is a category of misdemeanors in which the Office of the Chief Trial Counsel makes a determination that it is not a crime which may involve moral turpitude. So there is an initial determination that this is a crime that does not involve moral turpitude, and those matters are not transmitted. This has gotten lost somehow in our whole discussion. So there currently is and always has been discretion by the Office of the Chief Trial Counsel to look at something and say, oh, let's just say this was a single standalone DUI that happened 7 years ago. There's no possibility that this is going to result in a finding of moral turpitude, so they do not transmit it. The problem is that's a wholly unilateral decision. The court is not involved in it, and the respondent gets no opportunity, and believe me, we've tried to go and say to OCTC, let us have an early determination whether or not this involves moral turpitude, because if you agree that it doesn't, it will never move forward to a public proceeding. That's what's missing. That's what we are advocating needs to be developed and instituted. And I have to say, I agree with Ed. Most lawyers who are involved in a state bar proceeding, whether they're represented or not, are not seeking to delay. They are seeking to resolve it at the earliest opportunity, both because it takes them out of their practice, it's stressful, it's frightening, and if they have to pay counsel, it can become very expensive. So rather than pushing these things to trial, which now implicates the expenditure of court resources as well as prosecutorial resources, if we can resolve more of these cases early on, that will relieve the burden, not increase the burden. And finally, this came up also in this subcommittee. These restrictions, these time restrictions are simply unworkable. There is a backlog at OCTC, there's a backlog in the court. It is simply not possible to get to an ENEC in 15 days of requesting it. It's virtually impossible. And so it's a rule that's honored in the breach. It will not delay significantly if you have an ENEC within a few weeks of requesting one, any more than occurs now, because as a practical matter, this 15-day limit is an impossibility. So I really strongly disagree with the argument that this will delay the state bar court proceedings. It won't. Thank you.
All right, thank you, Ms. Pansky. And I need to take this opportunity. I'm actually in jury trial right now, and we're having issues that I need to wrap up this afternoon. So I'm going to drop off. Sean is going to chair the meeting. So thank you, Sean, for being available. And hopefully I'll be back in a little bit. But if not, thank you everyone for your work. And Sean, take the reins.
Okay, and thank you, Brandon. I just want to clarify one thing from what Ms. Pansky said. There were two different working groups, the ENEC working group and the moral turpitude working group. And a lot of the stuff is overlapping, so I understand why they're overlapping. This particular recommendation came from the ENEC and was looking at changes to the ENEC process. And so that's why this recommendation is focused to allow for criminal conviction cases an opportunity to have an ENEC. And so it's directly related with the ENEC process. The moral turpitude process that a lot of what Ms. Pansky was talking about, that decision whether or not there's moral turpitude or not, and that there is no opportunity for the respondent, or that OCTC solely makes that decision, I think that there might be recommendations. I know that you and Ed were going to work on recommendations to go from the moral turpitude working group to allow some sort of process to be developed. So I just want to make sure that those are two different things. And so this one is just about the ENECs and any changes to the ENEC process. And that's where these recommendations came from.
Well, just to clarify, Justin, I just want to respond to that. Everything that I've just addressed relates to the ENEC process. So there are crossover issues that still need to be addressed, but we are talking, in fact, about establishing a workable ENEC process in general and also extending it to the convictions. And I just feel that we are not in a position to vote today. There are more issues that we haven't addressed.
Linda Schneider. Linda, you have your hand up. Please go ahead.
Yes, thank you. I was part of the ENEC working group. We had 4 members, and our discussion of these topics generally ended up in a split of 2-2 on, decision making as to how we should go forward. It was generally Melanie Lawrence and I who kind of took one side, and Ed Lear and Judge Wang the other. So just letting you know where I'm coming from on this, and because I guess Melanie isn't here, I'll step up and speak a bit for the opposition. And the agenda item, the way it was written, is quite clear on the viewpoints of the opposition, I believe, but I just wanted to put a little bit of perspective on it as well. My experience is coming from representing agencies within the Department of Consumer Affairs, the licensing agencies, of which there are about 35 different agencies. And the NEC process is one that is quite unique to license discipline in California. Attorneys enjoy the ability to come in before charges are even filed, to have a voice and to try to settle the case, and to obtain, frankly, private discipline that's not available in other licensing arenas either. Private discipline is something that is disfavored in the law because it puts the public in a position that they simply never know that an attorney or a respondent has ever had any charges by the licensing agency. And so it deprives consumers of information that might be relevant to them as they try to select an attorney. So an example of that would be the Girardi case in 1999. He received a private reproval, and yet many consumers never would have known that. And we all know kind of what happened there. He's had numerous complaints with the state bar since then. So a private reproval is disfavored. It's something that is not available in almost any other licensing scheme throughout California. So I wanted to make sure that the members of the commission are aware of that this is something that's really very unique. Also, the criminal conviction issue is one in which the legislature has determined that the ENEC would not apply to that. And I don't know for a fact, but I would assume that the reason would be that criminal convictions are different than other kinds of cases where a determination has already been made that the respondent is responsible for this criminal conduct. So that's different than the other kinds of cases that come before the state bar, where facts have not been proven, responsibility has not been taken, etc. So there likely are reasons why criminal convictions are not subject to the same process as other kinds of cases. So I just wanted to point those factors out, that the public is deprived of the information that a person is charged with discipline, charged with disciplinary allegations during the ENEC process. The ENEC process does in fact delay the process. We learned during our meetings that the time differentiation between cases that have ENEC and those that do not is significant. I can't remember the exact number of days of difference on coverage, but it is quite significant. So those are factors to keep in mind as you consider this proposal. Thank you very much.
Thank you. All right, before we proceed further, we're almost an hour into our meeting. Focusing on the first, it's actually not a recommendation, it's just, what will we even call this? It's a proposal.
Yeah.
The first proposal. Would any member of the commission like to make a motion related to that proposal?
I would like to make a motion, and I would propose that we put the ENEC the ENEC proposal to a vote as articulated in the memo that Justin had circulated to us before.
So is that a motion to adopt the proposal?
Yes.
I'll interpret it as a motion. Thank you. All right, is there a second? Hearing no second, the motion fails.
I'm sorry, I was unmuting. I'll second the motion.
All right, thank you. Second by Ellen Pansky. Any further discussion? Oh, we got some hands. Ed Lear.
Yes, I would like to respond to a couple of Linda's comments. I understand and appreciate the need for public protection. I understand that the State Bar is a public protection agency. I need to note that in the ENEC process, whether this proposal passes or not, there is public protection that's embedded in the process. To wit, we are still in an adversary system in the ENEC process. To wit, we have defense counsel, we have a prosecutor, and we have a judge. An ENEC resolution is not a unilateral resolution by any one of those three. It is an agreed upon resolution that not only is one that may be advocated by a respondent's counsel, but is also one that is agreed to by OCTC. And finally, as a check and balance, the court has to sign off. So it could be that OCTC and respondent's counsel agree upon a resolution at an ENEC and a judge rejects it. So there are checks and balances throughout. This is a safe process. This is not any attempt to hoodwink the public and not disclose to them what's going on. This is something that only happens with the approval of the court. So if there's a private approval that happens at an ENEC prior to filing, which would make it what we call a private, there's by and by respondent, by and by judge, by and by OCTC. So there's public protection there. Further, I would stress that there's an ease to the system by resolving things early. There is no additional burden of going through the process. So even if a case, whether it's a criminal, whether it's a serious criminal conviction or not, even if it's resolved at an ENEC, it takes the burden off of the court system and off of OCTC insofar as the need for litigating, having a voluntary settlement conference, and then potentially having a trial. So in that regard, judicial economy may be the best feature of adopting the proposal in its stated form. Thank you.
All right, before I recognize Judge McGill, I do want to point out we're running a bit late on this meeting in terms of getting through our agenda. So I'm hoping we can proceed to a vote after Judge McGill speaks. I don't want to cut people off, certainly, but just consider if any further comments are necessary to fully vet the issues in front of the commission related to this motion. And Judge McGill lowered his hand. Thank you.
No, I guess I do.
Oh, you do need to speak. Please do.
Yeah, just brief. I'm just trying to make sure I understand Mr. Lear's motion. Is it just to extend the deadline for the transmission of criminal conviction matters and misdemeanor cases? It wasn't clear when Ed made the motion what exactly we were doing, and I just think we should be clear. Thank you.
Thank you. Thank you for that, Judge McGill. I think Justin's going to put it on the screen. The ad hoc, so the motion is to adopt the following proposition. The ad hoc commission on the discipline system recommends seeking a statutory amendment to extend the deadline for the transmission of criminal conviction matters in misdemeanor cases to allow for an early neutral evaluation conference. Ed, is your hand still up, or was that from last time?
Not still up, and that your screen accurately reflects what I was incorporating into my motion. Thank you.
All right, thank you. Seeing no hands, let's proceed to a vote, Justin.
Okay. Anderson? Bell?
Aye.
Buenaventura?
Aye.
Buffington? Chen? Duran?
Aye.
Rishardi?
Aye.
Farwell? Good. Jones? Joseph?
Aye.
King? Larkin?
Aye.
Lawrence? Lear?
Aye.
Mayorga?
Aye.
McGill?
Aye.
Judge McGill. Moat? Macau? Pansky?
Aye.
Rosenblatt? I didn't hear Eloise.
Aye.
Okay. Snyder?
No.
I didn't hear that. Sorry, Linda. What was that?
My vote is no.
Okay, thank you. Oleg?
Because I'm presiding, I'll vote only in the event of a tie.
Okay. Stallings? Judge Wang?
Aye.
Winfield? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 ayes, 1 no. The motion passes.
Thank you. All right, let's move to the second proposal related to the ENEC process.
Okay, in the interest of time, I will try and be brief with this. These are the support and against arguments for subsequent, for timeline, the development of timelines for subsequent ENECs. As I mentioned previously, the respondent has 10 days to respond to request an ENEC, and that first ENEC is supposed to be held within 15 days. I know we've heard testimony that it doesn't always happen, but it is supposed to. Multiple ENECs can be ordered if the judge thinks that settlement is possible. There are no time restrictions for those subsequent ENECs. And so this proposal simply asks that the State Bar establish timelines for those subsequent early neutral evaluation conferences. So I don't know if anybody wants to speak, of the commission wants to speak on this proposal.
Judge Wang.
Okay, thank you, Sean. I am against any limitations. I think there was some expression or frustration that was anecdotal that was driving this proposition. But frankly, I'm not sure what this accomplishes, because as one of the 5 hearing judges who hold the E&Es, I don't hold a second one unless everyone thinks that more time is needed, either from OCTC to reconsider its initial view of the case, or the respondents need additional time to get medical records or good character letters. So I think that this, I just don't think a fix is needed. I don't think this aspect of the E&E process is broken, in the sense that we hold second ones or third ones when the parties are in agreement, and if the court feels like there could be a benefit for doing so.
Thank you. Linda Snyder.
I just wanted to give a little bit of perspective from the working group, and that was that there seemed to be within the process multiple ENECs that slow down the process by which the actual disciplinary charges are filed, again, delaying that notification and notice to the public. And also, the statistics were that the multiple ENECs drag out the process even longer than if you don't have an ENEC, or if you just have a single ENEC. Understandably, counsel's calendars and everybody in the litigation process, the calendars have to be coordinated. But if there were some time constraints, these multiple ENECs given some priority over other matters, therefore bringing it to a resolution and filing of charges where warranted at an earlier juncture. Also, Melanie had made a very good suggestion regarding the process, because defense attorneys and respondents prefer to put in the ENEC process in order to have the goal of the private reproval where no public charges are filed. That's my understanding of an important goal. but her suggestion was that if there's to be more than one ENEC, that there only be multiple ENECs if the judge were to determine that there was a very good chance that a private reproval would be the outcome of the case. I thought that was a very good suggestion that Melanie made, but it didn't appear in the agenda item. Thank you.
All right, would you like to make a motion to adopt that proposal?
Well, my proposal would be to offer Melanie's suggestion that a subsequent ENEC not occur unless a judge determines that a private approval is the likely outcome of the multiple ENECs, or rather the likely outcome of the case.
All right, thank you. I will consider that a motion. Is there a second?
I second the motion.
Thank you. Second by Eloise. We'll continue the discussion. Actually, let's, if we could, let's focus the discussion on this motion, and then we can return to a more general discussion or other motions afterwards. George. Well, I think Judge.
I'm sorry.
Do you want to be heard, George?
Yeah, briefly. I'm not sure that any of these changes are needed. I read the rule as I think Judge Wang has made clear, that while the rule requires an initial ENEC, it doesn't require any subsequent ENECs. And so any subsequent ENECs would actually require it to be a voluntary process by the parties. And so OCTC has the ability to basically say, look, we don't see any basis for having a second ENEC because we don't think this is ever a case that's going to be a private approval. And so with that level of discretion there, I'm not sure that any changes are needed. Both the court, the defense attorney, and OCTC would have to all agree for there to be a second ENEC, which I think provides appropriate checks to making sure that it's only conducted where it's going to serve some purpose and then won't unnecessarily delay the process.
Thank you. Judge McGill.
Yeah, I guess to basically follow along with what George said, I mean, my experience when I was a trial judge, you know, we would have to do some talking to OCTC in order to get them to agree to an ENEC, but most oftentimes everybody agreed that there needed to be a second one in order to get more documents or further reflection. I never really found it to be that adversarial of an issue. So I'm real flummoxed as to why we would need to establish timelines, because I do agree with George. I know George hasn't seen the system as long as I have or Judge Wang has, but really it is fairly cooperative on that point. Judge Wang might want to correct me if I'm wrong, but I think she agrees with me about that. So I'm a little flummoxed about having this issue. I think just leaving it as it is, yeah, it's going to delay some things as the statistics show, but I found the statistics a little kind of myopic in a way that I read. So I didn't quite understand if they were really reflecting what was trying to be accomplished in the ENEC, because there's always going to be delays. I mean, there's 25 days to get to an ENEC. Then there's probably somewhere between 2 weeks to 30 days to get the ENEC. So you're already 60 days beyond what a non-ENEC case would be doing. And then if you had another one, you're probably going out to about 90 days. So I just don't see a lot of issue with this, and I'll stop talking to save time.
All right, thank you. Let me note that Sarah Good has joined us in the San Francisco office. She's not yet on Zoom, but she will be shortly. Ed Lear.
Thank you. I'll be brief as well. I do agree with George, and I agree with Judge McGill. My experience is that when there's a second and or a third ENEC, that it's always cooperative. There's always buy-in by all three of the stakeholders, and that it works that way. If OCTC has a strong reluctance to have an additional ENEC, and if the court can't convince them to do so, it doesn't happen. But when a judge feels strongly about an additional ENEC, then the other stakeholders usually can read the tea leaves, and it happens. And it's usually to the benefit of the entire system. So I don't see that there's a reason for timelines. Thank you.
All right, thank you. Judge McGill, your hand is still up. Is that like to be talk again? Okay, thank you. Justin, let's proceed to a vote.
Okay. Yeah. I want to make sure that I capture it so everybody knows what they're voting on.
All right.
Oops. That. Does that capture the original motion?
Almost. In the third line after only in cases in which the hearing judge.
I'm sorry. I can't, it won't let me edit it. Only in cases.
Okay, only in cases in which the hearing judge determines that, so leave that, then go to may. So actually just strike the whole rest of the sentence. Determines that a private reproval is a likely outcome. And then, Linda, may I ask, that's my memory of your motion. Did I get it right?
Yes, I think you
Oh.
did. Thank you.
All right, great. We'll get that on the screen. You're doing that, Justin. Always good to know what we're voting on.
Okay. Anderson, Bell,
No.
Buenaventura, Buffington, Chen, Duran,
No.
Shardy,
No.
Farwell, Good, Jones, Joseph,
No.
King, Larkin,
No.
Lawrence, Lear,
No.
Mayorga,
No.
Judge McGill,
No.
Moad, Macau, Hansky,
No.
Rosenblatt,
No.
Snyder,
Yes.
Beleg. Oh, you're gonna wait.
Pass.
Stallings, Judge Wang,
No.
Winfield, 11 noes, 1 yay. It does not. The motion fails.
Thanks, Justin. All right, let's return to discussion. And before we proceed with more discussion, would anyone like to make a motion for adoption by the commission? Hearing, if there's no motion to be presented, then I think we can move on to the next item.
Agreed.
All right. Why don't we take a 5-minute break and come back at about let's say 1:53. See you in a few minutes. All right, we're going to gear back up. In just a minute, we announced to the public 1:55, so. Is that, I see that turn, then we're going to go. All right, so we're going to resume. We've completed item 2A on our business agenda, and we will now proceed to item 2B, discipline costs and sanctions recommendations.
Okay, thank you, Sean. All of this information was in the memos. There are two recommendations that came out of the discipline costs and sanctions area. The first is that the ad hoc commission recommend that the Board of Trustees reevaluate its current discipline cost model with a focus on reducing costs. It includes, but not limited to, restructuring the cost structure so that attorneys are not penalized for going to trial and scaling fees when charges are dismissed. And then the second one talks about the elimination of the sanctions. Very quick background, because we've gone over the discipline costs at many other commission meetings. The current costs are based off a 2010 discipline cost study. They're for reasonable costs of investigation and hearing. They are tied to the consumer price index, so they go up about 2% a year, although in recent years it's probably gone up larger than that. We're talking about $1.5 million was budgeted for 2022 and $1.5 million was collected in 2021. And as a percentage of budget, you can see that the budget for State Bar Court and OCTC was over $75 million in 2022. These are the costs that we're talking about specifically. You can see that matters that settle prior to the notice of disciplinary charges are only about $3,600, but if you go all the way up through a multi-day trial, it's $20,000 for those original proceedings. And then if it goes to review department, it gets up to $24,000. So that difference between the multi-day trial and the review department is $4,000. And there's a significant difference between a one-day trial and a multi-day trial. This was discussed, and there was wide support expressed at the discipline costs working group. They are much higher than other state bars. And other comparable California regulatory boards. We surveyed other states, and most states were less than $3,000 in the costs that they recouped. Other DCA boards, it was pointed out, can only recoup the cost of investigations and a little bit of pre-filing, but not much, but not going to trial or review. There was a decision that basically said to recover costs of trial could be impeding the practitioner's right to pursue a hearing, and it would have a chilling effect on that. And then some of the arguments are respondents are responsible for the costs regardless of the outcome. So if there was 11 charges against them and they had 10 charges dismissed, but one minor charge they were found culpable, they had to pay the full cost of the trial. And the argument being that if they were only charged with that one minor allegation, they would have settled much earlier on in the process and only had to pay much, much less costs. And that also that respondents are penalized by going to review, even if they get a lower level of discipline as a result of that review, they still have to pay the higher review cost. And there is no discretion granted to the judges to lower those costs in any way currently. So that is the recommendation. I don't know, I'm going to stop sharing now and open it up to the commission if anybody would like to speak on discipline costs. In the past, this was not unanimous, but it was pretty close to support for this lowering of the cost or an investigation into lowering of the cost.
Thank you, Justin. Justin, actually, would you mind putting the proposal on the screen?
Sure.
And then before we proceed with the discussion, I'd like to know if we have a motion for action by the commission. Would anyone like to move adoption of, I understand people on the working group supported this, so would anyone like to move this item for adoption?
Well, hearing no one else make such a motion, I so move.
Thank you. Second by Sarah Good.
Okay.
Thank you both. Judge McGill.
Yeah, thank you. Just, I think something needs to be added to the motion, just a small addition. So that last sentence, this includes but not limited to restructuring the cost structure so the attorneys are not penalized for going to trial or seeking review and scaling fees when charges are dismissed. I think that we need to get that in there because that was part of our discussion, was also the fees particularly tied to review costs.
All right. Jerry, do you accept the amendment?
I do.
And Sarah? Yes. All right. Then the friendly amendment is adopted.
Sorry, I was trying.
In the last line, the penultimate line, after going to trial, add the words "or review." Okay, thank you. All right, Judge McGill. Oh, sorry.
Yeah.
You probably, did you want to speak further?
No, that was it. I just think, I mean, it's true. I mean, I don't think anybody that participated in the working group had really any objections to this
Okay.
recommendation.
All right, thank you.
And Melanie were there. I honestly don't recall them having an issue with this.
All right, thank you. Any further discussion? Hearing none, Justin, please take the vote. Take the roll.
Anderson, Bell, Buenaventura,
Aye.
Buffington, Chen, Duran,
Yes.
Rashadi,
Yes.
Farwell, Good,
Aye.
Jones, Joseph,
Yes.
King, Larkin,
Yes.
Lawrence, Lear,
Aye.
Mayorga,
Aye.
McGill, Judge McGill,
Aye.
Moad, Nakau, Hansky,
Yes.
Rosenblatt,
Aye.
Snyder,
Aye.
Stallings, Judge Wang,
Aye.
Winfield, "13 ayes.
Thank you, Justin. Motion passes.
And we will move on to the sanctions piece. So a brief overview. Again, this was included in the memo and we've discussed it at many meetings. They were authorized in 1994, but they weren't actually implemented until 2020. That's when the rules were promulgated and the guidelines were implemented. They are for cases that involve disbarment, suspension, or resignation with charges pending. The statute allows for up to $5,000 per violation or $50,000 per order cap. The rule 5.137 actually established lesser amounts. So for disbarment, it's up to $5,000. For actual suspensions, up to $2,500. And for resignation with charges pending, it's up to $1,000. Obviously, they can go up to the full amount in the statute, but these are the recommended starting amounts. There wasn't much support for the sanctions. When we did the research, we didn't identify other states or agencies that implemented sanctions or issued sanctions. And so within the working group, there wasn't a lot of discussion on keeping sanctions. There was kind of some support about removing the sanctions or eliminating sanctions. That is the brief presentation on sanctions.
Thank you, Justin. Would any member of the commission like to make a motion?
I move for approval of the proposal.
Thank you. Who was that?
That was Ellen.
Ellen, okay, thank you.
I
Is there a
second.
second?
Second.
Second by Ed Lee. Thank you, Ed. Discussion. Seeing no hands, Justin, please take the roll.
Anderson, Bell, Buenaventura,
No.
Buffington, Chen, Duran,
Yes.
Rashadi,
Yes.
Farwell, Good, Jones, Joseph,
Yes.
King, Larkin,
Yes.
Lawrence, Lear, Ed. I think Ed is frozen. He made second.
Oh,
I'll keep him off for right now. Mayorga,
Yes.
Judge McGill,
Aye.
Boad, Al, Pansky,
Yes.
Rosenblatt,
Aye.
Snyder,
Aye.
Stallings, Judge Wang,
Aye.
Justin, this is Ray Buenaventura. I had misvoted. Can you put me down as an aye? I'd read the recommendation wrong.
Sure.
Thank you.
Can somebody turn off the microphone?
Yeah, can we remind folks to mute if you're not talking? Thanks.
That's 12 ayes, 0 noes. That
All right.
passes.
all right, thank you. Sorry, I spoke over Justin. He said the motion passed. Next on our agenda is item 2C regarding expungement, which we're going to pass for the moment and return to later. We'll take up item 2D regarding progressive discipline recommendations.
If we can go attorney representation, if you wouldn't mind, Sean.
All right, that's fine. Let's do item 2F, attorney representation.
So as a brief history, the full commission was provided an overview of the Farkas report and the Robertson recommendations. The Farkas report looked at disparities in the discipline system, and the Robertson recommendations came up with proposals to address those disparities in the system. And as part of those proposals, one of the things that Professor Robertson was looking at was low bonal or other low bonal panels for attorney respondents, because one of the things that it showed for outcomes was attorney respondent representation had a big factor on having attorney representation. I apologize.
Justin,
Yeah.
your slides are not on the Zoom,
Oh, okay.
just FYI.
And so what we have here today are two different proposals to increase attorney representation. The two proposals were outlined in the memo, and the one distinction between the two proposals is one is a flat fee, and then the other is an hourly rate. And both proposals would be open to attorneys that currently qualify for the sliding fee scale. So there's certain income percentage or income amount where attorneys are eligible for a sliding scale of attorney's fees, and that's how they would qualify for this program. The hourly rate, the total pilot program would be $250,000. The attorneys would be reimbursed at $300 per hour, which is similar with other special discipline trial counsel or appointed counsel. So if a respondent has mental difficulties and needs appointed counsel, these are the hourly rates that we currently reimburse special deputy trial counsel. It's estimated, and this is only an estimate, that 83 attorneys could participate until the funds are fully exhausted, and once the funds were exhausted, no more attorneys could participate. And certain types of cases would be excluded. So if there's a high-profile case or there's a especially egregious case, those types of cases would be excluded from this process. The flat rate is a little bit different in that we would develop a panel of attorneys that would agree to represent for $3,500 for full service within a limited scope. So this is really focused at early intervention and eliminating jeopardy for suspension or disbarment, so reducing the charges they're facing, and only up through the early neutral evaluation conference. The program costs are the same, so it's the same $250,000. It's estimated that this would help potentially 71 attorneys. As the memo stated, there's usually around 200 attorneys that get involved with the discipline system that qualify for that reduced licensing fee every year. And it had the same exclusions for those certain types of cases. And so staff said that we would bring back recommendations to the full ad hoc commission. There wasn't a working group on this, but there has been work done between commission meetings. And so these are two proposals, one a flat fee and one not for attorney representation. I open it up to the floor now for questions and discussion.
Okay. Great, thank you, Justin. So let me make a couple comments here. So in this particular instance, I'm not going to invite a motion right away because we have sort of, it's a little more complicated issue, and I think some discussion would be useful. I think we really have three options in front of us. One is to adopt or recommend adoption of the hourly rate program. The second is adoption of the flat fee program. The third is to do nothing, in which case the staff has said they would come back to us with a pro bono based proposal. So with those three options in mind, and if anyone wants to put another one on the table, please feel free. I invite you to discuss. Eloise.
I have two questions. Number one, who would make the decision about the exclusion of certain high profile or problematic, heavy duty involvement cases that might potentially exhaust the fee? Secondly, my own experience as a family law attorney who also does wills and trust, I used to have a policy of a flat fee for an estate plan. I would not do that again because no matter what the presenting, quote, simplicity of putting together 5 documents, what I've learned is that there's always complications that extend my hours. What I thought would be a flat fee, straight arrow set of tasks inevitably involves complications, the need for documents, the need for follow-up, the need for consulting other attorneys, anyway, out of state matters. So I would recommend, I wouldn't, if I were an attorney qualified, which I am not, to participate in this program, I would recommend, I wouldn't do it for a flat fee. So that's my question and comment about, who would make the decision and then a recommendation for an hourly fee rather than flat fee.
All right, thank you. Ed?
I have several questions, and I do think that this one would be appropriate for a working group because there's so many things that are left unanswered. I think generally the concept is good and I'm in favor of it. I'm wondering, one, is there a cap for the hourly? Secondly, I'm wondering what happens if there's no early resolution through the flat fee, where there's an intent that there be an early intervention through ENEC. What happens after the ENEC when the matter is not settled? Thirdly, I'm wondering why there's an exclusion at all for the high profile / more egregious cases, which I think should fit into the categories 1 and 2. And I would also just like to add an anecdote, and that is that there is at present a structure that wherein attorneys who are subject to Business and Professions Code section 600C, 6007 matters, which are competency hearings typically, where the courts will at times appoint counsel. I have been appointed counsel. Ellen has been appointed counsel. When we do that at the request of the court, we are not doing that for the money. We are getting crushed financially on those. We do that as a favor to the court. And that is one of the things that I would consider pro bono, even though there is, I suppose, a $250 fee, but it's so restricted insofar as how, well, the way that structure works is that, for instance, for a court appearance, even if you spend 5 hours on the court appearance, the court has indicated a certain cap for the time that you can spend on that. And again, this is not a complaint. I don't have to do 6007 matters. I do them at the request of the court, and I understand and appreciate that they are pro bono efforts. And I would imagine that this is more or less going to come under that category. So to sum that up somewhat, I think that there are some questions that need to be answered. Perhaps somebody on this Zoom can answer them now, and we would all be better informed. But I am curious about all that. Structurally, philosophically, I'm very much in favor.
All right, thank you, Ed. Let me offer an observation. I think with a proposal like this, which is very unusual and path-breaking, I think, and then I'll see if Justin or Leah want to answer those questions. I think we should focus more on the concept than the details. And that, to me, the next step would be going to the board, and if this group recommends one of these options, seeing if the board agrees, and then I think the board would want to appoint some kind of a working group to flesh out the details. We can also, if the commission recommends one of these options at a conceptual level, we could also have a smaller working group work with staff as they prepare the report that's going to go to the board. And at our next meeting, we'll be looking at the report. So I guess what I'm suggesting is we shouldn't get too bogged down in the details, but rather, is this a good policy paradigm, right? Is it something we want to pursue? And then the details can be worked out. We may want to modify the language of the resolutions, the proposed resolutions, just a little bit to take account of that. But so that we can get through this and get it to the board, I think we should take that approach.
Yeah,
So,
I would agree. That's what I was going to say. I think if we could stick to kind of the policy level decisions, should we do it or not? A, B, if you are going to recommend it, would you recommend a flat fee or a fee capped kind of approach or an hourly rate approach? And any other kind of policy level considerations, like this issue of excluding egregious cases, that's kind of a policy decision. I think if you keep your recommendations at that level, that's appropriate to take to the board with the details to be worked out later.
Thank you, Leah. So right now, we'll continue the discussion. Leah's made a very good suggestion. So I'm now anticipating we'll vote on whether to do it at all. If the answer is yes, which model to adopt, or another model if someone has a different overarching proposal. And then this idea of excluding certain cases. If there's other sort of bigger issues that people think we should discuss and vote on, please let me know. All right, Ed, your hand is still up. Do you want to speak further?
No.
Okay, thank you. Linda Schneider.
Thank you. I wanted to inform the commission that as far as I'm aware in the Department of Consumer Affairs and as well as any other disciplinary system in California, that there is no attorney, pro bono attorney provision, no free attorneys for anybody. There is no constitutional right to an attorney in a disciplinary action. So it's really largely voluntary for respondents to hire an attorney, as well as the concept that of all licensees that exist in the state of California, an attorney is better prepared to be self-represented than just about anybody else that there could possibly be who's facing disciplinary charges. So I don't think it's a good idea. An alternative proposal might be to establish a pro bono panel within the state bar, so attorneys have the opportunity to serve others and fulfill pro bono path and maybe get experience handling state bar matters that would be beneficial to them in their career. Thank you.
Thank you, Linda. George.
Just wanted to turn to the question of who would make the determination as to which cases are excluded. And I just want to make clear that I don't think that could be OCTC, because that would put us in an impossible situation of making determinations as to which cases there might be representation against us. So that would have to be somebody else.
It would be a staff position to be determined. Outside of OCTC, undoubtedly. All right, any further discussion? All right, Jerry.
I just had a question back to the Farkas and Robertson report, inferring that part of the disparate impact of discipline on lawyers of color and Black males particularly is tracked back to the absence of representation disproportionately. Am I correct? Was that the theme of the findings and recommendations in the Farkas report?
Yes.
Yes.
Thank you.
All right, any further discussion? Linda, going back to your comments, would you like to make a motion to adopt a pro bono based program in lieu of the proposals in the memo? Because if the commission agreed with you on that, then that would render the 3 questions I identified moot.
Well, I'd be happy to make such a proposal. The proposal would be to establish a pro bono panel of attorneys that would volunteer to represent attorneys facing disciplinary charges before the state bar.
All right, thank you. Is there a second to that motion? Okay, hearing none, that motion fails. But thank you for making it. I appreciate it. Gary, your hand is up. Did you still want to speak, or is that from last time? No, okay, good, thank you. All right, so I would like to invite a motion that the commission recommend one of the paid options. Someone like to make that motion?
I'll make that motion, Sean. Judge Wang.
Thank you, Judge Wang.
May I ask a
Is there a
point of
second?
clarification? I'm a little uncertain. Are we going to be voting on recommending one or the other, or are we voting to say that the ad hoc commission recommends that a appointed council program be established either on an hourly fee basis or a flat fee basis? And that
Right.
has to be fleshed out.
Correct. I think it just before we like have someone make an option to adopt option 1 versus option 2, I just want to see if it's the will of the commission that some kind of paid option be adopted. Because otherwise the discussion will not be sufficiently structured in my view.
Okay. If that's the motion, then I will second it.
All right, thank you. Thank you, Ellen. Any discussion on the motion? Hearing none, Justin, please take the roll.
Anderson, Bell,
Aye.
Buenaventura,
Yes.
Buffington, Chen, Duran,
Yes.
Ricciardi,
Aye.
Farwell, Good,
Aye.
Jones, Joseph,
Aye.
King, Larkin,
Yes.
Lawrence, Lear,
Aye.
Mayorga,
Aye.
Judge McGill,
Aye.
Moad, Nakau, Pansky,
Aye.
Rosenblatt,
Aye.
Snyder,
Opposed.
Stallings, Judge Wang,
Aye.
Winfield, (13, 4, 1 against). It passes.
All right, the motion passes. Thank you, Justin. So next, I'd like to invite, if someone would like to make a motion to adopt one of the two options presented by staff. And Justin, I don't know if you have a slide on that. So if you support one of these options in particular, please make a motion to adopt it. And then while you're thinking, I'll suggest that I would modify the proposal slightly to say because we're not, in my view, we're not really, and we shouldn't vote on all the details. We're voting on kind of the overall paradigm. How about implement? So for the first one, Justin, implement a State Bar Court appointed counsel program. And then remove the dash and say based on an hourly rate structure. So and then left unsaid is that, you know, all of the details will be worked out through some process later on, as I've explained. And so we'll make the same changes to the second option. All right, would anyone like to make a motion? Ellen,
I
see you have
will.
your hand.
Well, I'd like to float the idea first that that the motion be that the State Bar Appointed Counsel program be based on the existing hourly rate structure that is currently in effect for B&P Code Section 607 proceedings. And my thinking is we already have a system, it already works, it's already in place. So why don't we just extend that same system to the appointed counsel program?
Hey, Leah, Leah or Justin, any comments on that?
No, and I think that's essentially what the hourly rate proposal is.
Yeah, it is modeled off of it. It's the same hourly rate that we pay those appointed councils, and the idea is to develop the same roster, and we just don't have the same information. As Ed was referencing, in the appointed council program, there are specific allotted times for specific events because that process is pretty the same. These would be a little different because it'd be different cases, there'd be different things, and we don't have those standards, but that's the details that could be decided later.
Okay, right, and let me, I also said as Justin was revising these proposals, the commission, could also just recommend that this $250,000 pilot program be adopted and not necessarily say whether it's hourly or flat fee, and the details can be worked out later, right? Because there could be more study of these issues. And that might be an attractive motion as well. So, Ellen, did you have in mind making a motion?
I'll move the proposal that, that you amended and that Justin has drafted based on the hourly rate structure.
Okay, and I think based on your prior comments, Justin, Leah, or Ellen, can we add just a few words to capture that idea, or maybe it's not necessary if that's the understanding, because that's what's in the memo. Leah, what do you think on that point?
I think it's always nice to have the resolution be clear. I'm not controlling it, so.
Okay, so can we just have I think what we need is an hourly rate structure similar to the blank program, which I don't know how to describe it.
I don't.
I think it's the 6007 program. Just take our court's current court appointed counsel program.
Ellen, is that amenable to you?
Yes.
All right, thank you. Do we have a second?
I second.
All right, second by Eloise, thank you. Is there discussion? Hearing none. Justin, when you're ready, please take the roll.
Anderson, L.
Aye.
Buenaventura,
Aye.
Buffington, Chen, Duran,
Yes.
Shardy,
Aye.
Farwell, Good, Jones, Joseph,
Aye.
King, Larkin,
Yes.
Lawrence, Lear,
Aye.
Mayorga.
I'm sorry, I had to step away to get on a call. Are we voting on the hourly rate?
We're voting on the first bullet, which is is similar to the hourly rate of the 6007 court appointed counsel program.
Yes. Aye.
Okay. Judge McGill,
Aye.
Moad, Nakau, Pansky,
Aye.
Rosenblatt,
Aye.
Snyder,
No.
Stallings, Judge Wang,
Aye.
Winfield, Well, to 2, it passes.
Right, thank you. And then I had identified as a possible subject of a vote whether there should be an exception for certain cases as described in the staff memo. I am kind of, and I'll invite anyone who wants to make a motion on that point to do so. Although I will say I'm kind of inclined to think that should be in the category of a detailed point to be worked out later. If staff has any comments on that, they're welcome, or any comments from our members. No comments. All right, would anyone like to make a motion before we move on to the next topic? Seeing none, I think we have completed this item. We'll move on. Progressive discipline next, Justin?
Let's do expungement, because I know that there are certain people that are going to drop.
All right.
It has recommendation. Progressive discipline didn't really come to conclusive recommendations. So it's a
I
discussion.
see. All right, very good. So we'll proceed with item 3C, expungement. And I know we're losing one or two people at 3, so we'll proceed until 3, and then we'll have a brief break. If anyone else has a scheduling issue, please let me know, and I'll try to accommodate it. So with that, Justin, please proceed.
Sure. Share my screen. All right. This is a topic that we have brought up at multiple ad hoc commission meetings. At the most recent one, on April 28th, we discussed the expungement recommendations. There are 2 different types of expungement recommendations, and one is more actually removal from the website recommendation, and then the second one is expunging of the discipline record. At that time, dissenting opinion from the working group, Mr. Steve Moab, said that he would work to provide alternative timelines. Those timelines were also included in the memo. So the memo proposed 2 different sets of timelines, and that's what we're going to discuss now. As a reminder, we've discussed about this before, but this is really what the expungement working group was focused on, and a lot of discussion came that they were trying to redress some of the disparities in the discipline system that were found in the Farkas report and also the Robertson recommendations. We've talked about the study, so I won't go over it again, but these were some of the findings and the major findings, and why the expungement working group was looking to make changes to what is on the website and to make changes to what is in the discipline record. Because currently everything stays on the website indefinitely, and there is no real expungement of the discipline record. And so the Farkas report said that black male attorneys were 3 times as likely to be placed on probation and also 4 times as likely to be disbarred as compared with their white male counterparts. With that framing, we did a lot of research and looked at other states and what they have on their websites. Most other states, I think there were only 2 states that didn't have anything on their websites. 2 of the larger states kept discipline on their website for 10 years, and that was Florida and Texas. So the expungement working group took that into consideration. And then we also looked around at what the other departments within California did, of the Department of Consumer Affairs agencies. And 2 of the main focuses were the Medical Board of California and the Board of Registered Nursing. And so this slide here is what the working group looked at to compare how attorneys were how attorneys compared to doctors and nurses. And as you can see, for public approvals, attorneys, that's a low level of discipline. The lowest level is a private approval that is sometimes public, but it is public indefinitely. And in doctors, it's 10 years from the effective date, and nurse it's only 3 years. So they examined comparable agencies, and this is the Board of Registered Nursing that has a very clear chart as to what is on their website. Discipline can be obtained if you call the Board of Registered Nursing, but this is what is on the attorney profile page. And we had public comment. This commission had a couple of members comment on the length of time discipline appears on the attorney profile page. They also commented that it's indexed by Google, so it's very easy to look up an attorney. When you Google their name, the State Bar Attorney Profile page is one of the top results that come up. And so the Board of Registered Nursing, trying to strike a balance, shows that these are the timelines for which it is removed. So they're trying to be transparent to the public in that. So the working group recommendations for when it should be removed from the attorney profile page for private approvals, which, as a refresher, a private approval is private unless it happens after the notice of disciplinary charges. The notice of disciplinary charges is what makes a case public. And so if the ultimate discipline is private after everything has been said and done, that is still public because the notice of disciplinary charges has already been filed. A private reproval is only private if it happens before the NDC is filed. So the decision was 1 year, or when conditions were met, it could be removed from the website. Public reproval, it was 3 years. Probation with stayed suspension, so no actual suspension, it was 3 years from the conclusion of probation. Probation with actual suspension, it was 5 years from the reinstatement from the suspension. And then disbarment was public indefinitely, so no change. And this is to combat the unlicensed practice of law. There was concern that if it was removed from the website that people could continue to practice and people wouldn't know. As detailed in the memo, I won't read everything, but it was to redress the findings in the racial disparity study, kind of trying to strike a balance of the public's right to know and attorney's ability to move past already fulfilled discipline. There wasn't consensus. There was dissenting opinions on these timelines. They thought that they were too slow or too short, and that it could be confusing if you could call in and get a different discipline history than was what is on the website, because we have become a very internet-based society and most people would just look up on the website and think that's what it is. The alternative recommendation that was developed, the private approval is very similar, the 1 year when conditions are met. The public approval is 6 years after conditions were met, and that was kind of striking a balance between the 3 years of the nurses and the 10 years of the doctors. Having that in between. 10 years for probation with stayed suspension and probation with actual suspension, it was 10 years from the conclusion of probation. They think the time period needed to be longer with that level of discipline, and then disbarment, there was agreement for no change for the concerns previously mentioned. These are more comparable to the other regulatory boards. The working group's recommendations are are comparable to nurses, but not doctors. And then, as I mentioned previously, the Florida and Texas have that 10 years where they keep the discipline before it goes off the website. So this slide just makes it simple so people can compare each of the recommendations, so you can see where the differences are between the two recommendations. And I think at this point it would be good to, I think at this point I'm going to stop sharing and let those that were on the working group cover things that I may have missed, or let the full commission know why they made the decisions, and then maybe take an adoption or a proposal.
All right. Sure, let's hear from members of the working group only right now, and then I'm going to propose a structure for how to discuss these issues.
Sure, I'd like to be heard.
All right, Sarah? Sarah, good.
So I was on the working group and strongly supported the proposed timelines that were adopted by the working group for one primary reason, which is a lot of the changes that we're talking about to the attorney disciplinary system are forward-looking changes, or changes that the state bar implemented post-Farkas report. But we're very concerned about what are we going to do to remediate disciplinary sanctions and history, particularly entered against Black men along the lines of the Farkas report, Robertson report. We're looking to how do we redress some of the wrongs of the past. We can fix it on a going forward basis as best we can, but what do we do about the past? And so these time periods very much reflect the notion, and you'll see this will be, the website time period will be the same in terms of expungement ultimately, because we thought the two should be transparent and there should be symmetry between the two. We felt that particularly folks in the past should have the opportunity to either get it automatically removed from their record, or to make a proposal to the state bar court where we would trust on our excellent state bar bench to administer discretionarily determining whether or not expungement was appropriate. So the website proposal and the ultimate proposal on expungement have been divided up, but the website proposal reflects the working group's proposal on expungement because we felt they should just be the same and be consistent. So I'll turn it over to anybody else in the working group who wants to comment.
Ray.
Yes, thank you. Let me just say that this working group really did work hard at coming up with some recommendations and some solutions. The recommendations that we brought forward, I think, will really impact in a significant way what the state bar does in terms of attorney discipline and the effect on the disparate communities. So this will change the way things are done, and this will have an impact. So I am alignment with what Sarah said about moving forward. This does move us forward. It will bring some change, and I hope you all see fit to vote to recommend it. Thank you.
Thanks, Ray. All right. Okay, so here are the three issues that I see for us. The first issue is whether we do anything in this area at all. So once I identify the, well, I'll come back to this, but if anyone proposes that we take no action in this area at all, we should discuss that first. The second is whether we should have the same rule for the website and the underlying state bar records, because we have, as you know, we have two different proposals for how to handle information on the website and two different proposals for how to handle the actual disciplinary records. So I think we should first decide, are we going to have two different rules for these areas or just one? Perhaps expedite the discussion. And then the third is which alternative to adopt, or some other alternative that a member wishes to propose by making a motion. So let me then take up the first issue. Is there anyone who believes that the commission should take no action in this area at all? And if so, please speak up and let us hear your views. Gary.
Sean, I'm torn here. You know, I'm guessing the working group was torn too. So while two other large states take matters off their website after 10 years, whatever the time frame is, and two don't have discipline on the website, it means 47 go the other way, including pretty well-respected jurisdictions like Michigan, Minnesota, Pennsylvania, New York, and others. I am concerned, and it might be resolved by how the system deals with disparity between what is on the website and what is really still an existing public record that can be obtained by inquiry to the office. That will not just confuse, it will mislead the public. Confusing is a nice word, but misleading is what it would do. So I also think the comparable to doctors might be better than the comparable to nurses. Just a thought I had. On the other hand, why I'm torn is we all have spent time with the Farkas and Robertson reports. And I understand Sarah's point and Ray's point and other points. I'm kind of torn here. So I wouldn't even make a motion on this, Sean. I'm just expressing my own personal views here, but it's not as easy as the other motions I've heard presented today for me.
All right, thank you. Eloise?
I'm speaking from my own experience of being surprised at the number of opposing counsel who have been disciplined by the bar, suspended, or have some record of not just private reproval. I'm a family law attorney, and I've had occasion to, just look. I make a practice of looking up who I'm dealing with, and in 7 cases that I've dealt, it surprised me. In other words, the state bar has been very active in the area of keeping a watch on family law attorneys. None of those attorneys were African American. what I found is that in most of those 7 cases, because I met 2 of them, they are persons of ethnicity who would probably not register on a survey as African American. They would probably be counted as white or Caucasian. So I feel like a piece of my experience, while I am very sympathetic to disparate treatment of any racial group, I wonder whether the original study considered, the demographic of, let's say, born out of the United States and practicing as an attorney. How many persons born outside the United States and are practicing in the area of family law end up disciplined, along with persons of who identify as African American or Black. So that's one of my concerns. The other is that again, and I think I said this before, that if these records had been wiped out after 3 years or even after 10 years, I might not have been on the alert that there was possibly an issue to deal with this attorney or to understand. So right now, I feel I would need to abstain from a vote because I honestly don't have, I'm kind of, compromised by my lack of information or by the conflict between my experience and the data that's been dealt with by the committee. So I simply respectfully submit that contribution.
All right, thank you. So let me pose this question. If there's any member of the commission who is against taking any action in this area at all, I invite you to make a motion, because obviously if the commission agrees with you, then that will truncate the discussion quite significantly. You're of course always free simply to vote no on all the proposals if you wish to. But does anyone wish to make a motion along those lines? Seeing none, then we'll move on. The next issue I'd like to focus on is whether the commission wishes to adopt the same principles for both the website display and the underlying disciplinary records. Do people have a view on that? Does anyone want to make a motion that there be 2 different methodologies, or that we adopt the same criteria for everything?
I'd like to make a motion that the 2 should be the same in the interest of transparency and consistency. And also because something on the website can easily be found later, whether or not you remove it. So I would make the motion that the 2 should be coterminous.
All right, thank you, Sarah.
I second.
Is there a second?
Second.
Second by Ed Lear. All right, discussion. George.
I just want to make clear and hopefully get an understanding that when we talk about expungement and public records, what we're talking about is not the absolute destruction of the record. In other words, that record will still exist. It simply will not be available to the public if they make a request for it. And I just want to make clear that that's what we're referring to as expungement, so that, for example, OCTC will still have the ability to look back at records, for example, to determine whether there's some pattern of prior misconduct. It's simply that it wouldn't be available to the public.
Yes, that makes sense. And here again, there may be, as with the council representation, there may be a good number of details to be worked out later. So for example, I expect the board would want to continue with the current practice that the Jenny Commission can see everything when considering judicial candidates, and there may be other considerations also, but we're sort of, those minor exceptions can be dealt with, I think, later when we get to more of a detailed stage. Jerry.
Thanks, Sean. I think you're really speaking of sealing a record more than expunging it then. But regardless, it seems to me that the idea that any licensing agency can make these records unavailable such that no one will know they exist is just not going to hold water. We at Illinois block the external searches into our databases. It's a pretty easy fix. Yet, when we've looked at this, there are newspaper articles all over the place, particularly if it's a little bit notorious. So what's going to happen is that Steve Moet talked about this in a little different context, is that a member of the public or Eloise or someone looking to know about opposing counsel is going to go to a bar website and find no record, authorized practice in good standing. They'll go out to Google and go out to all the collateral newspaper sources and see the lawyer was suspended for 3 years and is back in. So it doesn't land me in any more comfortable place than I was before. So I think I'm with Eloise on an abstention here myself. This is hard stuff because the competing values are important. And in my view, public record, transparency, lack of confusion, and serving those who expect to have a public record be available is one part of it. I read the Farkas report. That's there is a injustice done. So I don't think any individual case is necessarily wrong in its finding, but the length of suspension, all of that, and maybe even the choice to bring it might be impacted in a way that none of us would find appropriate at all. So sorry to wander around in my thoughts again, but this is, for all the times I've been with you, this to me is the most difficult question that I've had to grapple with.
And I just want to make sure if Sarah or Ray want to comment. I think what George said was discussed at the meeting, because we did kind of talk about the criminal expungement, and we went over, the Clean Slate Act and other things, and that there are exceptions. The expungement is useful for employment or, obtaining housing, but there are certain exceptions to that I think George is talking about, like if you're lottery commission or running for public office, or there are certain things, but I want to make sure that the working group members have that same recollection.
Before you do that, let me interrupt procedurally. Judge Wang, I believe you said you'll need to take a break from 3 to 3:15.
I would like one. I would like one.
And is there anyone else now online who we're losing at 3 or at some specific time?
I had said I had to leave at 3, but I'll stay till shortly before 3:30 and then I have to go.
And
very good.
That's pretty much me with Ellen. Yes, shortly before 3:30, I have to go.
I can go until about 3:20, Sean.
Oh, all right, then let's.
I can avoid the 3 o'clock break.
Okay, thank you. So we'll try to take a break around then. So Sarah, please proceed. I'm sorry to interrupt.
Yes, and I'm sorry, I lost my train of
Well, my devious plan worked then.
Well, I just wanted to make sure that the working group's recollection is what George, because George has talked about exceptions, and we did discuss those at the meetings, and there was some understanding that there would be certain exceptions for the Jenny Commission specifically.
I think, in fact, I raised the Jenny Commission exception, and then also this proposal does not mean to eviscerate the whole concept of progressive discipline. And so obviously in progressive discipline, if something's been expunged, it could still be taken into account, which I think was George's point. So this does not interfere with that process. Hopefully that made it clearer, not more opaque.
Yeah.
Yeah, and I think, again, we don't have to work out this level of detail, but I had a question when I looked at the criminal expungement statute. It was a little confusing to me because it seemed to be saying that either the plea or the guilty verdict would be vacated, but then it's deemed to exist for certain other purposes. It was a little hard for me to get my head around that, but I think those kinds of details will need to be worked out further by staff and the board if the commission adopts this at sort of a high level, policy level. Judge McGill.
Thank you. So this is becoming one of the the most difficult issues. And let me just give you some perspective from the state farm court. I think we need to really kind of take a moment and step back and look at the reprovals and the probationless state suspension versus actual suspension. When you look at the type of conduct that we typically place into those lower categories of discipline, those really are what I call the scarlet letter kind of situations, because people, that's usually relatively minor conduct, or it could be a little bit more serious misconduct, but the person had a lot of mitigation that factored into it. But those cases, those people walk around, and I've had people tell me many times that in those lower level cases, if they're in a court hearing, and they've been operating fine for many years, you know, the opposing counsel doesn't hesitate to bring up to a judge if they think they can score some points. This person's been disciplined, and the anecdotal stories I get on that is, you know, I kind of did my time, I took my lumps. Now, you know, it's being used against me every single time. And then I think we've had one or two people have come to the commission talking about how those lower level disciplines have really had an effect on their career when that's the only problem that they've had. So again, I don't have a problem with expungement there. Maybe expungement suspensions are becoming, that becomes a little bit more uneasy, at least from my viewpoint, as somebody who's, you know, regularly making recommendations to the Supreme Court on those things. I really don't know if this is the time to adopt this kind of recommendations. I think it's better if we had to take something to the Board of Trustees to say that you need more working group time on this, because really, I do agree with Ms. Rosenblatt on one thing. I mean, these are kind of the issues that touch on public perception of what the attorney profession is. And if it's going to look like we're hiding stuff from people without really good reasons, it could become a real problem with the bar, with the public, the legislature and the like. So I don't know if this is a good time to take this proposal forward today with our group. If not, just continue it over to our final meeting on the 29th, have some more time to think about it. I think a lot of people seem ambivalent about this, and I don't think it's a good idea to have a vote that's very small with a lot of ambivalent votes, abstentions there. I don't think that's going to look good for us going forward.
Well,
Can I make a comment?
yes, please.
So Judge McGill, I certainly appreciate and respect your decision. As a member of the working group on this, we spent a lot of time grappling with the issues, exploring different processes and procedures. You know, Justin has detailed much of that work. I don't think we need more time. It is a difficult issue, but I think we just need to vote it up or down and move forward. And I know, you know, as part of the working group who supported these proposals fairly unanimously with you know, at least Mr. Moad, strong dissenting opinion there. You know, we need to do this to remediate on behalf of Black men who, you know, were disproportionately targeted by the state bar's discipline system. And if we don't act, that's kind of saying we don't care. You know, we're not going to remediate. So I think it is critical that we move this forward. And if we took the view that it's hard and we're not going to, then we're not going to make any progress whatsoever on many of the other numerous initiatives that we are going to have before us. Thank you.
And I will say we do have time pressure with meeting the board's deadlines. So we do need to wrap this up. My recommendation would be, if you're unsure, take the approach that I long ago adopted with ballot propositions, which is if I'm unsure, especially if it's something that the legislature or the city council or whatever can do, then it's a no. And an abstain is really going to be a no, is the equivalent of a no. So it's your decision to vote as you will, but that would be my recommendation, because we do need to bring this process to a conclusion. Also, if someone wants to make a motion, you know, wants to make a motion that we ask the board for more time, or that the board set up another group to study this issue in particular, you can make any motion you like. Judge McGill.
Just one point of clarification. So can I have some idea, or can we have some idea of what the relative strength within the working group was between the two sort of approaches on the length of time? Because I don't really I can't see that in the report.
Sarah, would you like to answer that?
I think Justin probably has the accurate number.
Sorry, I didn't hear.
You're looking for the vote, Judge
For the
McGill?
vote count.
Yeah, so it's sort of the vote counts between the shorter timeframes and the longer timeframes. The idea of the strength of those two proposals.
The working group was made up of 6 members, and Shalon, Joseph, Sarah, Ray, Michelle Anderson, Martin Winfield, and Steve Moad. And there was consensus between actually, I don't know if member Joseph's here, she can speak for herself, but I know Mr. Buenaventura, Ms. Good, Mr. Winfield, and I believe Ms. Anderson, there was consensus on the proposal here. Steve was the lone dissenter. I don't have the actual vote. I'm going off my recollection. I don't have the vote totals handy right this moment.
Okay, thank you. Sarah was nodding, so that seems consistent with her memory. Okay.
Exactly.
Ed.
Thank you. I'm a little surprised about the controversy that this has engendered. Our entire justice system in this country is based upon redemption and second chances. And philosophically, that's what the framework of what we're proposing here, which is to say, in my business and Ellen's business, good people make mistakes. And I was particularly moved by Judge McGill's anecdote of the Scarlet letter and giving a second chance to those people who are good people who have made mistakes, who nevertheless carry around the Scarlet letter for the rest of their careers. The proposal, philosophically and otherwise, is giving an opportunity for those with Scarlet letters to prove to all of us that they are deserving of a second chance. It's not a freebie. They get disciplined. They have to meet the conditions of probation. They have to deal with the Scarlet letter, and they basically have to rehabilitate and over a period of time. And they have to show that they're deserving of getting that other chance of having the opportunity afforded to them for expungement. It's what we do in our criminal justice system. It's what we should do in this system as well. Rather than looking at what the other administrative agencies are doing with their professional licensees, the state bar can lead. The state bar can make an example for the other boards. I know that the nurses do it. I know that the Department of Real Estate does it. After 10 years, there's an expungement. Those expungements are earned. And I don't think that there's any reason to have further study. I think the time is right. I think Sarah has very well articulated the position of her working group. We appreciate all the work that they did on this issue, and I think we should vote.
George.
So Sean, I don't remember, Steve Moad isn't here, he couldn't be here today. So I'm not sure if we're talking about the 2 competing length proposals or if we're still just on whether there should be some modification.
The motion on the table is, and it really should be phrased perhaps in the hypothetical, because of some commissioners, I think, are members are really on the fence, that if the commission recommends some kind of expungement mechanism, should the rules be the same for what is displayed on the website and how the underlying disciplinary records, for lack of a better term, are treated, right? Because right now we have 2 alternate proposals for each of those scenarios. So
if that's what is on the table, I would say I tend to agree with Jerry that they should be the same so that we are not in the position of essentially not including something on the website, but having it available for public request, which creates the perception that we've deliberately concealed it from our website.
Right, understood. All right, so why don't we proceed to a vote on that issue? And it's always your prerogative to vote as you would like. But on this issue, I would recommend that you assume that the commission is going to do something in this area, and do you want it to be uniform across both areas or different, right? It doesn't mean it doesn't mean you're voting to adopt the scheme, but otherwise if this commission adopts something, your view might not be taken into account correctly. So if that makes sense to everyone, let's proceed with the roll, please, Justin.
Could we just clarify again what motion was?
If you want to tell me what, I can throw something up on the screen so people know what they're
Yeah,
voting for.
so, actually, you can strike that introductory language, Justin. It's because this isn't really a recommendation, well, just strike the whole thing, because the only way I can think of do it is a different way to do it. So it's just going to be, if the commission.
Justin, do you think you're screen sharing right now?
No, I was going to
Okay,
type it out
all right.
and screen share.
Yeah.
So you guys don't see all my typos.
Okay, on the discipline system then, recommends an expungement process to the board, should the same rules be recommended for both the website and the underlying disciplinary records. If someone has a better language for that, please jump in. But what is the, see what the memo says. It just talks about the record. Okay, that's good enough for our purposes. So that's a question. Because this is sort of just a preliminary step in our discussions. It's just really to frame our discussions.
Right.
Okay, so so Justin will put that up on the board. For this purpose, I don't need a vote. It's really more in the nature of a straw poll. Sorry, I don't need a motion.
We should be.
All right, so Justin will take a straw poll on the question of if the commission recommends an expungement process to the board, should the same rules be recommended for both the website and the disciplinary record?
Anderson, Bell,
Yes.
Buenaventura, Ray. I didn't hear that.
No, I think Buenaventura was no.
Okay. Buffington, Chen, Duran, or Shardy,
Yes.
Farwell, Good,
Aye.
Jones, Joseph, King, Larkin,
I abstain, Sean, sorry about that.
Oh, no need for an apology. That's fine.
Lawrence, Lear,
Yes.
Mayorga, Judge McGill,
Aye.
Moad, Macau, Pansky,
Aye.
Rosenblatt,
Abstain.
Snyder,
Abstain.
Stallings, Judge Wang,
Aye.
Winfield. So that is 1, 2, 3, 4, 5, 6, 7. Does not pass.
We have 7.
We had 15 at the roll call.
Okay, so it's kind of a straw poll. So 7, tell me how many yeses, how many nos, and how many abstentions, please.
7 yeses, 1 no, and 3 abstentions.
Okay, for the purpose of a straw poll, I think the sense of the commission is we should have one rule. So I'll structure the discussion going forward with that in mind. And so we can take that down, Justin. Thank you. By the way, before we continue the discussion, I want to clarify my prior discussion of the significance of a no vote versus abstain. I'm not telling anyone how to vote. Please feel free to do it. I think what I should have been more precise is that if you abstain from the question of whether to adopt the program as a practical matter, if the program will not proceed at this time, because if that's going to be our vote, we're not, unless someone wants to make a motion to go to the board and ask to extend this process or have a different process, which I wouldn't recommend, I'm not encouraging you to do that, then that will be the effective vote. Feel free to abstain if you want to, make a record that you're unsure. I think that's a fair point to make, and I can sympathize with that. So, all right, so now we are down to the question of whether, if at all, to adopt one of the 2 alternative proposals. And what I would suggest is that someone who supports the working group's recommendation make a motion to adopt it, and then we can have further discussion and a vote and see where we end up with. That would mean if you're in favor of the alternative proposal or some other proposal you wish to make, then you would vote no on that motion, and then we would continue our proceedings. Okay?
I will make the motion
All right.
to adopt the working group's proposal.
Thank you. Motion by Sarah. Is there a second?
Second.
Right. And to be clear, because the proposal and the material was bifurcated for the website and the disciplinary records, this would apply to both, okay, based on the straw poll, unless anyone has an objection or a concern. Well, actually, I should say, Sarah, is that, you're
That's correct.
the maker of the
That's
motion?
correct. Yeah.
All right, and who seconded?
I did. Ray.
All right, and is that clarification acceptable to you, Ray?
Yes.
Thank you. All right, is there further discussion before we have a vote? Yes, George.
Again, since Steve isn't here, I will try and speak on his behalf in support of the longer time periods that he proposed. And I think it's important to recognize, while I certainly appreciate the concerns with remedying past, that this is a proposal that will apply not just to the past, but to the present and to everybody. And in effect, the shorter timeframes will be significantly less than what either nurses or doctors do in terms of making public discipline that has been imposed against their members. Discipline that, from a public protection point of view, people should know about when they are going out to try and determine whether they want to have an attorney placed in a position of trust in connection with their representation. And I think the proposals of time that Steve Moad put together that essentially put lawyers somewhere between doctors and nurses, despite the fact that there's a very good argument that lawyers should be treated the same as doctors since they are professionals, exercising discretion in positions of high levels of trust in connection with complicated proceedings that the public simply cannot by themselves understand and make reasoned choices about, and in which understanding and knowing whether there's been discipline imposed is a very important factor. I think the longer periods that are consistent with other states and with what we do with doctors and nurses make more sense.
Thank you, George. And just to reiterate, procedurally, if you agree with George, you should vote no or abstain on the motion on the table, and then presumably someone who supports the alternative proposal will make a motion to adopt that, and that will be your opportunity to vote yes on that if you so choose. Eloise.
I just want to say again, I feel that the committee and I myself feel choice. The first choice is sympathy and empathy for righting injustices done in the past, which I also think have not included persons outside the United States. But secondly, the other choice is the whole purpose of the commission, which is to the whole purpose of the State Bar, that may protect the public. So I feel torn between two goods, but an impossible choice represented by this particular proposal at this particular time. So I think you might well be torn in goods that I don't think this proposal resolves.
Thank you, Eloise. You were breaking up a good deal. If you want to call back in on a phone line and highlight your points again, you're welcome to do that. I think we got the gist, but you were breaking up.
It might have been your connection, Eloise, and it sometimes helps to turn off the camera while you're speaking. And
yeah.
Okay. All right.
All right.
Let me just repeat briefly. Is this? Can you hear me now?
Yes, that's much better.
Okay. Well, one of the few times that not seeing me makes it easier. My my point is that I'm torn between two goods, a Sophie's choice, between empathy, sympathy to right the injustices done to a particular ethnic group. I also think, based on my own experience, that there are other ethnicities that have been impacted disparately by state bar because they were born outside the United States, but because they're Caucasian, they may not have been included in the demographic. So that's one good. The second good is that fidelity to the State Bar Commission's mission to protect the public. And also, I do not feel that the present articulation of this proposal at a particular time helps me resolve my feeling torn between these two goods.
All right. Thank you, Eloise. Karen Bell.
Thank you. Yeah, I just wanted to note, I agree with the basis of us wanting to protect the public, and that, of course, is very important. But we're talking about people who've already done their time in this case, that have already been held to be rehabilitated to the point where they're allowed to practice law. So all we're talking about now is this punitive element about advertising their past misconduct or past errors, when if we really were protecting the public and we thought they shouldn't be working as attorneys, then they shouldn't be working as attorneys. But if we're saying that they can and they can practice, then I don't understand what is to be gained by further advertising the past, other than simply being punitive and harming their ability to make a living. So I don't really think that it's serving the public at that point. I think that that we're conflating issues between people who have done wrong and needed to be rehabilitated versus it's already done. It's happened, and now they need to be able to make a living. And this advertising their past, I don't really see what justice is served there.
Thank you. Leah?
Yeah, I think just to follow up on those comments, I think it's a little bit dangerous to just create this dichotomy that you're either for public protection or you want to address racial disparity. I think that's like overly simplistic. I'm not sure how we're protecting the public by having a 20-year-old discipline record on the website. I think we really would need to articulate how that is protecting the public. And I think that question goes well beyond any concerns about racial disparity. I think it's an appropriate question regardless of the race of the respondent. So I just wanted to offer my thoughts on that.
Thank you, Leah. Any further discussion before we have a vote? Hearing none, Justin, please take the roll.
Anderson, Bell,
Aye.
Buenaventura, Ray, I didn't hear you. Is that an aye? Okay. Buffington.
He voted visually?
I got a yes.
Yes, okay, thank you.
Chen, Duran. Rashadi.
Aye.
Farwell, Good,
Aye.
Jones, Joseph, King, Larkin,
Abstain.
Lawrence, Lear,
Aye.
Mayorga,
Aye.
Judge McGill,
Aye.
Moad, Howe, Pansky,
Aye.
Rosenblatt,
Abstain.
Schneider,
Abstain.
Stallings, Wang, Judge Wang.
And I do need to take a 10-minute break. So I'm not breaking the quorum, right, Sean?
No, I think we'll take a 10-minute break after this vote also.
And
Try to sync up
Winfield.
with you.
Okay, thank you.
That's 1, 2, 3, 4, 5, 6, 7, 8, 9. 9, 4, 3 abstentions. It passes.
Motion passes. So that concludes this item. We'll take a 10-minute break and return at 3:35. And Jason, check me on this, and we have one remaining item, which is adoption of progressive discipline recommendations, which we expect to be a discussion only. Is that right?
Yeah, there was no formal recommendations, but we can have a discussion.
All right, very good. So we'll see you all at 3:35.
I'm gonna sign off for the day, so thanks, everyone.
Okay,
Bye, everybody.
thank you all. All right, everyone, welcome back. I don't believe we announced this before, but we won't be taking up item 2E, moral turpitude, because we don't have recommendations right now. We will now proceed to item 2D, the last item on our agenda, regarding progressive discipline recommendations.
Okay. Start my video again so everyone can see. This is a report from the Progressive Discipline Working Group. And this working group met a couple of times. They discussed the issues in depth, but due to the complexity of the issues, the case law, and several different factors, they weren't able to come up with concrete recommendations. The purpose of today is to kind of provide an overview of what the Progressive Discipline Working Group looked at, and then if there are any follow-ups, if the Commission wanted to make any type of recommendations around the areas that they were thinking about making recommendations, we could entertain that, or this is just an area that may sunset and go away. The two areas that they were considering making recommendations were around the standards. Standard 1.8 that talks about prior discipline, and the Progressive Discipline Working Group wanted to look at that because of the Farkas report, and that prior discipline might have been due to disparate impact. Should there be different considerations for progressive discipline now than there was in the past? And if I can. So this is standard 1.8A, and it says if a lawyer has a single prior record of discipline, the sanctions must, and that highlight of must is intentional because that is an area of focus for the Progressive Working Group. Be greater than the previously imposed sanctions unless the prior discipline was so remote, and I won't read the rest of it, but where the working group looked at is, should there be a language change from must to may, or something lesser than must in this standard? The other area where the Progressive Working Group was considering is standard 1.8, and these are mitigating. Maybe there could be things that were added to this to increase the mitigation. They toyed with a couple ideas, but they never really, there was no cohesion around adding anything specific to this, but this was an area where the Progressive Discipline discussed and looked about making changes. These were kind of the themes in the working group discussion as to why there should be changes for progressive discipline. And it wasn't unanimous because there was opposing sides that said the Supreme Court has consistently expressed support for the standards and progressive discipline. So this is kind of an area where they think that there is support from the Supreme Court. And whatever is done, increasing that discretion could lead to more disparate impact. So there was a little bit of caution that you may be doing something to try and help, but it could also end up hurting. And so the focus on increasing the judicial discretion was one of the areas. So because we're taking recommendations for all of the other areas that the working groups looked at, I felt it was necessary to bring this working group's recommendation, or it didn't have a recommendation, but kind of give a summary of what was talked about and what they were focused on for the full commission. And I know some of the working group members aren't here. Judge Wang was integral in that working group, and I think Steve Moab was there too. But I want to open it up now in case the ad hoc commission members have questions or want to entertain a discussion or recommendations. There isn't any recommendations put forth by staff because there wasn't anything concrete from the working group, but we wanted to continue the discussion if the ad hoc commission deems it appropriate.
All right, would anyone like to be heard? Ray.
Yes, thank you. So I am very much in support of some reform when it comes to the area of progressive discipline. And you know, I go back to what our charge is in this committee, which is addressing the effects of the disparate treatment of Black attorneys. So I think the very fact that we are accepting the notion that Black attorneys have been unfairly disciplined, then why are we allowing that past discipline to have an effect on any future conduct and get them progressively sentenced, and obviously in a more higher level. So I think the fact that we have a system in place that brings back past conduct and attempts to try to correct it by saying we need to punish that offender even worse than before, I think is problematic. And so I do believe that we need to change it, and I certainly believe that we need to strike the must from the language, and at the very least, substitute in with may. I'm finding it hard to understand why more discretion would result in a worse outcome. You know, I come from a criminal law background, and when there is, for example, prior strike convictions that the prosecutor wants to use against my client, it's those discretionary factors that I'm able to use in an attempt to strike that prior conviction. And the more factors that I can use, the better outcome it is for my client. But now, so the issue is, I also think what discretionary factors, we could add to a long list of discretionary factors, sure, but we can also make it broad enough that we can try to fit, you know, whatever mitigating circumstances are in categories that are broad enough to be all encompassing. So I do think progressive discipline needs to be addressed. We shouldn't just allow it to sunset, because it is a way that we need to deal with the wrongs of the past. Thank you.
Thank you, Ray. Justin, can you remind me, the disciplinary standards were adopted by the board, right? Just for my own information.
Yes.
I think so. Yeah, but they're discussed extensively in Supreme Court cases and what's the word? Sort of approvingly. Now, that leads me to my point. We don't have a recommendation from the working group, nor from staff, but members are free to make a motion to have the commission make a recommendation if they so choose. So bear that in mind if you want to see action taken. Jerry.
I agree with Ray that this is a topic that shouldn't be sunsetted. I'm guessing, but I haven't looked at the Farkas report, that this was a significant correlation in terms of the disparate outcomes for particularly Black male lawyers. I also want to pick up on what Leah said in the last segment. It's also fair across the board. My own experience is that our boards have a lot of discretion in Illinois to essentially discount steeply anything that is remote in time. And so whether the answer is to create some motion in limine to get it out of the case, or some other way of positioning the prior discipline more effectively, as a discipline prosecutor, I like relator is a better term. Remote discipline hardly ever helps me. It just, our boards won't go there. And they're right, that we don't go there ourselves anymore. So I think it's a fairness issue across the board, and I would really be, I don't know how this committee and the board interacts, but I don't think consideration of this issue should be allowed to sunset.
All right, thank you. So
I'd also like to make a comment.
yes, please. I mean, I'll just say that if you want the commission to take action, this is the time to do it and make a motion. And I think one of the things I saw in here, it seems like one proposed reform was changing the word must to may in one of the standards, right? So anyway, I'm not encouraging it one way or another because I'm presiding, but I just want to be sure people understand they have the ability to do that if they wish. Sarah.
I was going to say I was also on this particular working group, and so I do second Ray's comment. I will say part of the difficulty of grappling with this issue is not knowing what we're doing about expungement first. And I do think the expungement piece is sort of a necessary correlate to what we're going to do with expunged matters and progressive discipline. Because we don't want to get rid of progressive discipline, but yet what are we kind of going to do with the two? So one way to deal with it might be to have this taken up once the board has made a final decision on expungement, what that looks like, to figure out how to maintain progressive discipline, but kind of work with those new constraints. So I think that was part of what we were dealing with, is there were just so many unknowns, if you will.
Okay. Jerry, your hand is up. Not sure if you want to be recognized. Nope. Okay. Any other comments?
I have a comment. I think progressive discipline can be appropriate in the right circumstances. I think there should be more discretion for the court. I agree with Jerry insofar as the court typically gets it right with respect to not considering remote discipline in its factoring of progressive discipline. And that is to say, I don't know a judge that on our court that would consider unrelated discipline from 20 years ago in the consideration of meting out the appropriate discipline in a progressive manner. The defense counsel, we have tools. Remoteness in time is one. There's a case called Sklar, that's the other. So we have tools to argue that progressive discipline is not appropriate in every context. I would like to see more discretion to allow the judges to deviate in appropriate circumstances.
All right.
So I'll make a motion then, along the lines that you suggested, which the working group talked about, which was trying to give the state bar bench more discretion to consider things or not consider things as they deem fit. So that would be replacing the must language with may. So I'll make that motion.
Second. I'd second. I'll add my second to Ed's second.
All right, thank you. Justin, do you want me to?
Yeah, if we could get.
Or Sarah can recite it. Do you want me to, or would you like to, Sarah?
I think we can take the language from your other
Like one of the earlier ones?
No, right, where you talked about may. Wait, I think it's, oh, sorry.
Yeah, that has the language for 1.8, so.
Oh, I see.
So the recommendation would be to change standard 1.8.
Mm-hmm.
Yeah, I would say, well, the way Sarah expressed it, which I think is good, it would be something like to permit the exercise of judicial discretion. Commission recommends that standard 1.8 be amended to replace the word, quote, must, end quote, with, quote, may, end quote. Yeah, you can always put the full name later. Would change to be amended. Oh, actually, I guess be amended to change, sorry.
Or to replace.
That's even better. Change to with. After the must. Replace must with may.
Inclusive decision-making here. Good modeling.
All right, so this motion is on the table. Is there further discussion? I see, George, you have your hand up. We have two Georges. George Cardona first.
Yeah, I was going to suggest that you may want to consider should instead of may. In other words, it seems to me that it would be appropriate to have a presumption in favor of it while giving the court discretion. And I think that also works better with the unless clause. In other words, we're establishing a presumption unless the things that are set forth in the unless clause are there, as opposed to simply having a permissive, which then doesn't make as much sense with the unless clause.
Sarah, do you accept that as a friendly amendment?
No, I think I prefer may.
Okay, thank you. George, would you like to make a motion to amend the motion?
I cannot make a motion. I'm not on this commission.
Oh, you're not on the commission. All right. If you agree with George, you may wish to make a motion to amend the pending motion as George suggested. All right, Greg Fortescue.
Yeah, I just would like to comment, as somebody who spends a lot of time looking at these discipline cases when they come to the court, one of the things that we look to when we are reviewing the decisions of the review department is how they're applying these standards and deviating from the standards or prior case law, that they provide sufficient explanation as to why. My concern with changing the standard to may and then including the unless, it makes it a very squishy standard. And it makes it very difficult, I think, for the court to assess when are we deviating, what are the circumstances. The way I have always read the standard actually is it does create a degree of discretion because it's a must and then unless, and it provides situations in which we wouldn't necessarily impose a higher level of discipline in those circumstances where it's remote or the prior discipline was not as severe as to warrant progressive discipline in this circumstance. So to the extent that the group is wanting to increase the level of discretion, I think we need to be explicit as to what are the factors that should be considered when we're moving beyond this, because it's a standard that the court gave to the state bar.
Got it. So procedurally, what I would recommend is if you agree with Greg, if you agree with this proposed language, vote yes on the current motion, and then we can have a second motion to make a recommendation about development of factors, presumably based on existing case law. Greg, is that acceptable to you, or would you like to make a motion to amend?
Well, like George, I can't make a motion. I'm not a member of the.
Oh, you're not a member. All right.
No, I'm a liaison from the court.
Got it. Okay.
I'm just
for clarifying.
Yeah.
All right. Any further discussion on the pending motion? Yes, Judge Wang.
I'm sorry, Sean, I missed the beginning of this discussion. So is the what's being proposed is the standard as it reads with a replacement of the word must for may.
It's May. Correct.
I actually agree with George and Greg to a certain extent that grammatically that sentence would no longer make any sense. And frankly, I was on the progressive discipline working group, but we did not really iron out specific changes. And what I think is premature, I do think it's premature for us to tool with the language. So to give people some context, so when you have a statutory amendment to like the penal code or a statute, what happens is there's a decision that kind of flips the code, right? It makes us reconsider what the intent was. And so there's this natural push and pull through, either through the legislative process or through the court and some amendment. So I guess my motion would be to study this more carefully. And as a neutral, I'm more comfortable with the idea of taking case law and amending the rule based on what we have in terms of decisional law versus just kind of a scattershot view and an amendment of the rule, frankly. So, but the way it stands, I don't think it makes any sense to say if a lawyer has a prior record of discipline, the sanction may be greater unless. That just doesn't, I have trouble with that language.
All right, thank you. And just to be sure everyone understands procedurally, if you agree with George Cardona, then you would want to vote no on this and perhaps change the language to change must to should generally be. If you agree with Judge Wang, you should vote no and make a motion to recommend to the board that there be further study. These are all options, but I just want to be sure everyone understands procedurally how to achieve your point of view if you want the commission to take a certain action. Karen Bell, I thought you had your hand up, but it's not anymore.
I think Judge Wang basically covered it, so I'm good.
All right. Okay. Further discussion on the motion?
I think I'm inclined to withdraw the motion.
Okay.
And recast it.
All right.
And have the new motion be to permit.
Oh, hold on 1 second. Who seconded, Justin?
I think it was Ed.
Ed, are you okay with withdrawing the motion?
I am, and I'm just about to second Karen's new motions as soon as she makes them. Or I'm sorry, Sarah's.
All right, so the motion is withdrawn. Sarah's now making a new motion.
So the new motion would be that the ad hoc commission recommends that the state bar study and adopt modifications to standard 1.8 to permit the greater exercise of judicial discretion in imposing progressive discipline.
I didn't. That was really well said, and I was behind you.
Recommends to the state bar, or to the Board of Trustees, that it analyze further standard 1.6, modify the language to permit the greater exercise of judicial discretion in imposing progressive discipline. Period.
Did you mean
1.8 or 1.6?
both? 1.8 is the second offense has to be more disciplined than the first.
Why don't we include both?
Okay.
So in other words, we wouldn't get into the nitty-gritty of the word choices now, but we would recommend that it reflect the greater discretion in the state bar bench around progressive discipline.
And just to be clear, I think the use of judicial discretion is good rather than state bar court, for example, because these cases also go to the Supreme Court.
True.
And while Justin's proofreading that, is there a second to the motion?
Second.
With regards to progressive discipline, not prior.
And Ed, that was you seconding?
No,
That was me, Ray Buenaventura.
All right, thank you, Ray.
You're welcome.
Share it.
It's okay. All right,
Recommend 2.
yeah. Motion on the table reads as follows. The commission recommends to the State Bar Board of Trustees that it analyze further standards 1.6 and 1.8 to modify, modify them. Yeah, well, I shouldn't rewrite it, sorry. To modify the language to permit the greater exercise of judicial discretion with regards to progressive discipline.
How about that it analyze and modify standards 1.6 to permit,
Okay,
just to,
all right. Ray, is that acceptable to you?
to
Yes, it is. Absolutely.
Thank you. Okay, Ray, just to double check that the current language is acceptable to you as the seconder?
Yes, Your Honor. Yes.
Thank you. Ed Clear has his hand up.
yes, I was just about to second Sarah because I thought she was going a little bit of a different direction. And the reason that I did not is because while I agree with the essence of the motion, I think we're at a point now where we could recommend more specific language and take up George's recommendation of replacing shall with should, because I think should gives the appropriate degree of discretion to the court and satisfies the intent of what the motion that's on the table is professing to do. So that's why I did not support the motion as worded.
So you support the use of the word should?
I do, which is not pending, but that's
Okay.
that's where I stand.
Understood. So procedurally, to keep this simple, rather than a motion to amend, if you agree with Ed, you should vote no on this motion, and then Ed can make a new motion. Great. Does anyone want to be heard? Don't see any hands, so just, oh, wait, Judge Wang.
At this point, Justin, are you here?
Yeah, my camera won't turn on. I apologize. I am here.
At this point, does it make sense for me to share with you what I would, the suggested changes I made to 1.8?
Judge Wang, pardon me for a moment. Could everyone who's not speaking be sure you're on mute, please?
See, I don't want to get into the weeds with this full commission. I had hoped we could do more work in coming to some kind of consensus, but I do have a detailed starting point in revamping 1.8. But I don't know if that's appropriate now. That's why I was more appropriate with the motion to look at this in greater detail. There is a long line of cases that discuss progressive discipline. Then we had Silverton in 2005, where the Supreme Court said to the hearing judge at the time or the review department, no, the review, it went from hearing to review to the Supreme Court, where it says, look at the express language of 1.8, and you were not applying the express language of 1.8. And so the challenge for me as the hearing judge is to look at 1.8, look at all the law pre-Silverton, look at 1.8, the express language, and the handful of cases discussing 1.8, which is very few and far between. So I'm trying to figure out where my discretion is. And so I think a more careful study of where the court has gone before, looking at the language of Silverton, and I think that makes more sense to me. But I do have a proposed revamp to 1.8.
Okay.
So is it appropriate to move the question, call the question?
Hold on one second. Let me, Judge Wang, let me suggest to you, based on what you're saying, I think that sounds too complicated for the commission to take up right now. So I wouldn't recommend that. And I think procedurally, if the commission adopts the present motion, then the Board of Trustees agrees with the recommendation, then it's going to set up some other process to study this, probably with a smaller, more focused group of people on that particular issue. So I would hold your fire for that, so to speak. But is your proposal consistent with the proposed language of the motion?
Well, that's why I don't know where we were going with this. If we're going to go into the weeds and talk about the modification of the rules, then I think, all the stakeholders need to get together and we need to talk about what may work. So, because it sounds like the discussion is veering towards actually modifying the rule. And if we're really going to go into that, then I guess my motion would be that we shouldn't do that.
Well, the current motion is to recommend further study and modification.
Okay.
But we're not getting into the details of exactly what the modification should be.
Okay. All right. Thank you.
That'll be a later process. Okay. All right.
Thank you.
Someone called the question. I forget, that's supposed to be voted on technically under Robert's rules, I believe. Someone.
I did, but I withdraw that call the question so you could proceed here.
Okay. All right. Karen Bell.
I just have a procedural question because I'm not sure how the meeting was noticed. I don't have the agenda in front of me, but I don't know if it was noticed that we're allowed to take action on this item or not. So just a question.
Thank you. That's a very fair question. You don't have to publish ahead of time each and every motion we might adopt. We have to agendize the subject matter. So the public knows the topic will be discussed, and I think this motion is perfectly within the notice subject matter, so we're good from a Bagley-Keene standpoint.
Okay, thanks.
So thank you for raising the issue. It's an important one. Ed.
Yeah, I just wanted to modify my earlier position. I agree with the wording as indicated, and I value Judge Wang's comments.
All right, so you're supporting the motion now?
Yes.
All right, thank you. Any further discussion? Hearing none, Justin, please take the roll.
Anderson, Bell,
Aye.
Buenaventura,
Aye.
Buffington, Jen, Duran, Rashadi,
Aye.
Farwell, Good,
Aye.
Jones, Joseph,
Aye.
King. Oh, sorry. King, Larkin,
Aye.
Lawrence, Lear,
Aye.
Mayorga, Judge McGill, Moad, McCall, Pansky, Rosenblatt,
Aye.
Snyder,
Aye.
Stallings, Judge Wang,
Aye, thank you.
Winfield. 5, 6, 7, 10.
All right. Passes with 10 yes votes. Thanks, everyone. Is there any other matter a member wishes to put in front of the commission by a motion? Hearing none, I think we're ready to adjourn. I do want to thank everyone who hung in here for the whole meeting today and also for your work on this very long and detailed process. A lot of thought and effort has gone into this. I thought the memos that were put in front of us today were very, very thoughtful and well done, and I appreciate all the work of the working groups and the staff that went into that. I can't remember. So the next step, our next meeting, at our next meeting, the staff is going to present to us a draft report to the Board of Trustees based on the votes we've taken today. And then that is presumably going to be the last meeting of our commission. And I think we've accomplished a good deal, so we can be proud of our work. With that, we stand adjourned.
Thanks, everybody.
Thanks, Sean.